What about furnishing of copy? You would have filed it, isn't it?
The ROC.
Yes.
This company has submitted it more than 5 years. Submitted to some other study done. Marad, will verify Marad if it is not there, Marad will correct.
It was a 97, no, the same company was bound up. Connected matter, same company, not by a different petition. 97 winding up order was served to the ROC by the letter dated 4/10/2021.
It is submitted that the intimation to the ROC regarding winding up
Winding has been submitted in CP number.
has been complied with. Believe.
26, Mahadevan. This is not Tarika. Serial number 26.
26, Marad. Office official will get it corrected.
At request of the official liquidator, it's the matter week after next. Week after next.
Marad, in this case, Marad,
Yes.
I have filed a memo for fixation of upside price, Marad. Last time I see the valuation report and click that. Yes.
You have a copy of the valuation report.
Yes.
And just take me through the relevant.
But he has given three valuations not based on my report
Page 2 of
my memo, Marad. Right on 16th.
yes. Yes.
I have given the fair market value as per the valuation report. P gross 57 lakhs 27,000 and the reliable value 321. And of course, distance and
So which is the value now? That is
we will say the fair market value. Marad.
the official liquidator. Okay. By CH-12 of 2021.
Sorry, this valuation report was obtained by Bangalore Catholic Cooperative Bank Limited, Bangalore, one of the secured creditors.
It's 3 minute error 3.1. Bangalore Catholic was the second creditor. Copy of the valuation report was given to them for their comments. And they have replied no by their email to 2022 stating that they are satisfied with the comments and they are happy with the
Valuation also. Page 3 minute, whereas 3.1.
is the official liquidator. Short form. Fixation of a minimum upside price for the property. The result of the valuation report, copy of which is produced at annexure A, is further submitted that the said valuation report was circulated to the secured creditor. Was also addressed a communication at annexure B. Light of the submission that secured creditor has no objections as regards to the market value indicated in the valuation report. After having perused the valuation report, the fair market value as mentioned in the valuation report of 3 crore 57 lakhs 27,590 is to be taken as the offset price as regards to the property at survey number 125 and 126 within bracket P, plot number 241, Baikampadi village, Suratkal Hogli, Mangalore Taluk, Dakshina Kannada district. In the valuation report, where do you find this? 3 crore.
I repeated that valuation report. Page 12, man.
Page?
Page 12. After the tabulation, as a result of my appraisal and analysis, it is my considered opinion that fair and reasonable present market value of the above property prevailing conditions so is
Yes. Further steps for sale to be taken.
Round figure may be mentioned as a upside price, 3 crores 57 lakhs or 3 crores 58 lakhs.
3 crores 60 lakhs. 3 crores 60 lakhs. So the value, the valuation report suggests 3 crore 57 lakhs as an upset price. So we fixed it at 3 crore 60 lakhs. Yes.
27.
I appear for the respondents in both the cases, Your Lordship. Your Lordship, Senior Counsel Mr. Holla was to lead us in this matter. He's in the midst of a Barthard matter, Your Lordship. It may be posted next week, Your Lordship, any day.
My lord, I appear for the petitioner in COP 136. This is the matter where your lordships was pleased to keep the second application for transfer to NCLT in abeyance on the last date of hearing. In fact, we have argued on the main, my lord, on 7th
Yes,
of
it is
January.
for our reply, Your Lordship, on the main petition.
Let us see, we'll relist it next week and close the matter.
My lord, may be taken as finally.
We'll see in his presence only, we'll take it up. Finally, if they're going to argue, in their presence, we'll hear both and see. Relist the matter on 24th.
I'm obliged.
Petition 30 agents. Still number 31. B. Pramod.
Lords, I appear for the petitioner, my lords. Lords, in this matter, my lords, on the previous occasion had directed me to go to the Nitish Residency Hotel judgment and make submissions, my lords. Lords, I passed on that copy of judgment to the court master, my lords. Lords, in that matter, my lords, in that company petition, respondent had filed an application to transfer the matter, my lords, to the NCLT under the IBC, my lords, provisions.
So here what has happened? Any proceedings initiated
No, my lords.
before the
My lords,
NCLT?
what happened in this matter is, my lords, in the notice was ordered, respondent appeared, they filed objections. After that, my lords, IBC proceedings was initiated before the NCLT, my lords. At that time, my lords, matter was adjourned. Now, my lords, that proceedings is totally concluded, my lords. It's not there. It is
But what has
concluded.
happened? Now, what has happened? What has happened before the NCLT?
My lords, along with the memo, I placed that order, my lords, 25th August 2021. I placed
Yes,
the order.
25th August 21.
25th August.
21.
Wherein, my lords, that tribunal has disposed of that application, my lords, and resolution plan, my lords, of the resolution applicant is allowed, my lords.
But then if resolution plan is allowed, then you may have to work out a remedy there itself.
Lords, that matter is closed, my lords.
Correct. But if the resolution plan has been accepted, is decision. So if the resolution plan is accepted, then what happens to the winding up proceedings? If the resolution plan before the NCLT is accepted, and let's assume that his interest of the petitioner is not taken note of in the resolution plan, then what happens? Later third. No, now it's disposed even after that. Then you find out. Just examine that position.
Please.
Now, if it is the resolution plan has been accepted,
Please.
now if your claim has been left out, then you may have to. They just examine that point once again.
Well, please, lords. I want some time, my lords.
Yes, yes. The request made on behalf of the petitioner to the bits that you would examine the effect of the proceedings before the NCLT or in the list the matter after 2 weeks.
Much more.
Number 32.
I appear for the petitioner, my lord.
Lord, I appear for the respondent, please. Lord,
My lord, in this matter,
Yes.
my
Yes.
lord, I appear for the petitioner, my lord. In this matter, the petitioner is a government company, Kaveri Niravari Nigam, and the respondent had approached the government company to lease some lands in order to set up hydroelectric power projects all over. Now, what has happened is the petitioner entered into a lease agreement, which is in Annexure D, page 44 of the petition.
Entered into a lease with
With the respondent. This is for lease rentals.
Yes.
there are two units which were leased out to the respondent. That is Unit 1, Unit 2, and Unit 3. Annexure D is Unit 1, and Annexure E, which is on page 63, is Unit 3. Both these lease agreements were dated 30/12/2000.
Yes.
And the lease was for a period of 30 years.
Yes.
If your lordship may please see page 47, I have given the typeset in case your lordship it is not clear. Which is on page, no, page 47, the typeset equivalent is on page 56. Because the print was not very clear, man. Your lordship.
This is with respect to Unit 1.
Yes, the same thing. Unit 2, my lord. It's Unit 2 and Unit 3.
Annexure D is Unit 2.
Yes, my lord. Annexure E is Unit 3. It's 2 and 3.
Yes.
Now, if your lordship has the typeset or the other?
Yes. Type copy.
Type copy from page 55 onwards.
Yes.
If you, the lesser in their order has given by the order dated point number 2 on page 55. Point.
Yes.
The lesser in their order dated NEI land required to set up the hydroelectric hydel units being 36 acres of 4 units adjacent to Hebagavadi branch in the village limits of Chikkamalagudu and all the various areas. The main thing is this Chikkamalagudu, Sibanhalli, Bhimahalli, Gopalahalli and Kodumalahalli, Malavalli, Madur taluks of Mandya district. Now, the same thing, if Lord may see, in the typeset for Annexure 3, or in Annexure E which is Unit 3, we have again leased out some more lands to them. So basically, Unit 2 and Unit 3 were the same, were all lands in the adjoining villages of the Malavalli Madur Taluk of Mandya district. Now, my lord, now I will have to refer to their statement of objections because they have filed one document which is very relevant, which is on Annexure R2, page 26. Sorry for the inconvenience.
You can't be so polite. You have to make out your case.
I apologize because I know you'll have to go because this whole thing has to go. Annexure R2, page 26.
Yes.
Now, Annexure R2 is an agreement dated 3rd April 1996.
Yes.
In this annexure, we had agreed to lease lands to where the respondent, where they changed their name. Those are all those documents which will come subsequently. Now, in this annexure, if your lordship may see, para 1, which is right below.
Now, what is R2?
R2 is an agreement prior to the lease deed.
Yes.
In this, they have said in para point number 1, right below the para, the ownership of the unit would vest with the company for a period of 30 years from the date of commissioning the powerhouse. The company undertakes it shall not hypothecate the site structures, installations, machinery, building, etc. Thereon for any period longer than the period of the sites are leased to it by the government or Strash Power Corporation for 30 years, etc. Now, my lord, if you may please turn to page 28. This is the most important point. Point 2. The land required by the company shall be acquired by the company either from the government at, this is a very important, at a nominal amount of 1,000 per annum, or such annual lease amount as the government may determine from time to time for the period of above mentioned 30 years. So we can keep this rent. They are saying it be 1,000 or at an annual lease rent as the government may determine. This was in 1996. Now, if we will have to go back to our lease deed, based on this 2 units, the lease deed,
Yes.
the lease deed, which is on page 48 of my petition, Annexure D.
Yes.
The amount of lease rental in the 8th line from that, my lord, to have and hold the same unto the lessees for the term of 30 years, in addition to the construction and commissioning of a mini hydel plant, unit number 2, reckoned from 30/12/2000, date of handing over possession of the demised premises, at a yearly rent of 10,000 rupees per acre, payable from the 1st December each year, which shall be increased by 10% once in 2 years on the previous year lease rent. The first year's rent has been paid by the lessees by DD number so and so, that is amounting to 83,250.
Now this 83,250 is calculated at 10,000 per acre. According
at 10,000 per acre, and this is the same for unit 3 also, my lord.
Yes.
In unit 3 also, if you may see, it is on page 67, because the property was about the same size. So that is also in page 67, which is unit 3. This was also calculated at 10,000 per acre. He has paid a DD for unit 2 as well as unit 3 in the year 2000, when the lease deeds were signed, at 10,000.
Yes.
Thereafter, every 2 years, there is an escalation clause. When
Yes.
the lease deed was signed, he never raised any objections. He never said anything. Even my agreement with him said it could be 1,000 or at any rate that I fix it. Thereafter, he started, when he sends us a letter saying that he wants it back at 1,000 rupees. When we asked him to pay our lease rentals, he refused to pay. He kept on asking us to go back at 10,000. He is a businessman, a prudent businessman who has signed with full open eyes, looking into this lease deed, paid the DD for both unit 2 as well as unit 3 at 10,000 per acre for 1 year. Thereafterwards, whenever we kept asking him for the rent, which are the various annexures, he refused to pay us. Instead, he filed a writ petition. The writ petition was dismissed, and again he filed an appeal, writ appeal, which is on page 105, annexure M. This writ appeal was dismissed on 7th September 2012.
Annexure?
Annexure M.
Page?
Page 105. Page 105. Now on the order on page 110.
Now the respondent themselves have filed this.
Filed it. Yes, my lord. The respondents themselves, Vijayalakshmi Hydropower.
Yes.
If you may see on page 110, fifth line. So far as the other relief, if the appellant has given any
Yes.
if the appellant has given any representation to reduce the rent from 10,000 rupees to 1,000 per annum, it is between the lessor and the lessee in respect of the immovable property to alter the terms and conditions of the contractual obligation.
What was the writ petition filed for?
To reduce the rent, my lord. He wanted the rent to be
That was this is a wrong statement. The writ petition was only challenging the demand notice made. It is not to reduce the rent.
Demand notice was for the payment of the rent, which they did not want to pay at 10,000 rupees. They wanted it at 1,000, which is the same which we have come here.
Read the observations made.
Yes, my lord.
At starting from para 3, let us see what the dispute is.
Yes, my lord. It is the specific case of the appellant that in order to set up a mini hydel plant in Hebagawadi branch canal of 3 MW capacity, obtained an order from the state by its order dated 16/2/1996. Thereafter, government agreed to grant certain extent of land on lease for a period of 30 years and yearly lease rent of 10,000 per acre, which shall be increased 10% once in 2 years. Accordingly, land in Madur and Malavali taluks were granted to the appellants under registered lease deed. Pursuant to the registered lease deed, appellant paid lease rent at the rate of 10,000 per acre. For subsequent years, lease rent was not paid, which resulted in the respondent demanding lease rent with interest at 18% per annum as per Annexure K, dated 15/2/2005 and 9/1/2006 as per Annexure K, M1 to M4. In the meanwhile, appellants also gave a representation to reduce the lease rent from 10,000 per acre to 1,000 per acre on the ground that some other land government granted lease at the rate of 1,000 per acre as lease rent per annum and that he is not liable to pay rupees 10,000 per acre per annum, and that representation of the appellant has not been considered by the government to reduce the rent. Writ petition was filed. Learned single judge, by his order dated 16/11/2008, dismissed the writ petition, challenging the legality and correctness of the same. Present appeal is filed. We have heard the government advocate and Mr. M.R.C. Ravi, learned counsel, appearing for Kaveri Niravari Nigam Nimyata. The questions that arise for consideration of this court in this appeal are whether writ petition filed by the appellant was maintainable, requesting this court to issue a writ of mandamus to alter the terms and conditions of registered lease deed in respect of immobile property. Second, whether the demand notice issued by Kaveri Niravari Nigam Nimyata calling upon the appellant to pay the arrears of lease rent pursuant to the registered lease deed can be quashed. Admittedly, contract between the appellant and the respondents is in this regard to lease of an immovable property pursuant to a registered document. It is not in dispute that the appellant has paid the lease amount at the rate of rupees 10,000 per acre per annum for some years. Thereafter, he has not paid the same. If the lease amount has not been paid by the appellant and he is in arrears, and if a demand is made by the respondent, no writ can be issued to cause such demand notice, as the notices issued by the respondent as per Annexure K, M1 to M4 are based on a registered lease deed. In the circumstances, we cannot find fault with the order of the learned single judge if he is declined to issue a writ of mandamus to quash annexure K, M1 to M4. So far as the other relief is concerned, if the appellant has given any representation to reduce the rent from 10,000 per acre per annum to rupees 1,000 per acre per annum, it is between the lessor and the lessee in respect of an immobile property to alter the terms and conditions of a contractual obligation. No writ is maintainable. In
Now,
the
insofar as,
circumstance,
yes, insofar as the request, now you have stated that you are not inclined to, or you have not decided on that representation.
no, that representation has been decided, and that is also order has been passed, which the government advocate has filed it in your lordship. It is must be.
Representation was rejected in the year 2017, my lord, for which I have filed a separate writ petition and the dispute is pending before, my lord, the
And
coordinator.
then he has filed on the same thing.
Representation was kept pending, my lord, since, if I may be permitted to, my lord, make my submission.
May
I'll
I
come back.
make one
I'll come back to
submission?
you. I'll come back to you.
Please, please.
Now what I want to know is,
Yes, my
after
lord.
the writ petition order, you have declined the relief, or what has happened to that?
We have declined the relief, my lord. We have asked
Where
him
do
to
you-
pay the money at 10,000.
Where do you get that? Where do you get that declining?
Yeah, my lord, which you can see from page annexure 111 onwards. The translation, everything, we have put the correct figures. By the High Court orders in the case number, we have declined it. We have repeatedly been sending him annexure N2.
No, just
Annexure.
one. Any one order or communication subsequent to the High Court order wherein you have declined it.
Lord, I have it with me, my lord. It is not on record. It is dated 19/10/2017.
No, my lord.
This is their order, my lord, rejecting my representation.
1910.
2017, my lord.
Yes, let us see.
If I can read it, my lord, if my lord permits, my lord.
It is on the file, my lord. It was filed by the government advocate. My lord, if you may please see, it has been filed by the government advocate. It is on the file, my lord. It was separately asked to be filed by the government advocate.
So this is the affidavit of the Chief Secretary, is it?
Yes, my lord. They had asked the chief secretary to pass an order. If your lordship may see in the previous order sheet of the court.
Yes, you read that affidavit.
I don't have the affidavit, my lord. It wasn't given. It was
The affidavit is separate, my lord. The order rejecting my representation, there is a separate document issued by the Energy Department in the year 2017. That is not on record, my lord. Affidavit of
that is with the affidavit, my lord. It was filed with the affidavit. It was filed with the affidavit. But the government had informed that they had filed it directly because the chief secretary was asked to pass this order.
Yes. Now that 1910-2017 is along with the affidavit.
Yes, my lord. It should be with that. We were not given a copy, but we have the order.
Of that, my lord, because government put it on record.
But
But
read that.
I have a copy of that order, my lord. If your lordship permits, my lord, I can read
Yes,
it.
yes. Read it.
My lord, the relevant portion, my lords will find, my lord, from page 5 onwards, internal page 5, my lord, page 5 of the document. Page 4, if I may request, my lord.
Yes.
There is a heading, the representation of Mrs. Vijay Lakshmi Hydropower Limited has accordingly been considered. My lord, got it?
Page 4.
Page 4, internal document, my lord. I don't know the page numbering in the document in the file, but that order dated 19/10/2017.
Yes,
my lord,
yes.
my
Yes,
lord,
yes.
got it? The main contention of Vijay Lakshmi Hydropower Limited is that as per clause 2A of the agreement dated 3/4/1996, the government was required to provide land at rental of rupees 1,000 per annum per acre. But the irrigation department unilaterally fixed the rent at 10,000 per annum per acre. And as such, the same is contrary to the condition of clause 5 of the lease deed dated 30/12/2000, wherein it is expressly agreed that the parties shall abide by the conditions set out in the agreement. As observed, under clause 2A, the agreement dated 1996 states that the land required for the company shall be acquired by the company either from the government at a nominal amount of rupees 1,000 per acre, or such annual lease amount as the government may determine from time to time for a period of above mentioned 30 years, from private owners. As per the above, government has reserved the right to determine the annual lease amount from time to time. Accordingly, government determined the lease rental at 10,000 rupees per acre and enhanced leased amount of rupees 2 years at the rate of 10% for each subsequent years. Thereafter, by government order dated number so and so, dated 16/10/2000. The two registered lease deeds both dated 30/12/2000 were signed and executed by Vijayalakshmi Hydropower Limited, agreeing for the lease rental of 10,000 per annum per acre. And Mrs. Vijayalakshmi Hydropower Limited was fully aware of clause 2A of the agreement dated 1996 and government order number so and so. And after fully understanding the terms and conditions thereof, it is relevant to note that Vijayalakshmi Hydropower Limited has not challenged any provisions of the agreement dated 1996 and government order number dated 2000 or the two lease deeds dated 2000. Therefore, the lease deed became concluded contract between the parties. If Vijayalakshmi Hydropower Limited were to be agreed by government order dated 16/10/2000 or for the lease amount agreed in the lease deed, nothing prevented them from declining to execute the lease deed. It is for the same reason the Honorable High Court also dismissed the writ petition as well as the writ appeal. It is also relevant to note that Vijayalakshmi Hydropower Limited had also given a letter dated 31/1/2012 addressed to the executive engineer, wherein it is stated that we would like to inform that we will abide by the Honorable High Court of Karnataka and make payments as per the verbate. In the meanwhile, we request you to arrange for entering into lease agreement with you for Unit 1 on lease basis at rate of 17,715 per acre. We are agreeing to pay the lease charges as indicated. It is seen that the lease rent of 10,000 fixed in 2000 with escalation of 10% every 2 years will become 17,715 per acre during 2012. Therefore, it is obvious that Vijayalakshmi Hydropower Limited has accepted the lease rentals as decided by the government in the year 2000 by the above mentioned government order. The present representation requesting for reduction in rates has been submitted after Honorable High Court has dismissed the petitions by the company and also after the company had given the letter dated 31/1/2012 for lease for further piece of land at the same rate fixed by the government at 10,000 per acre without escalation. On this ground alone, the representation for reduction does not merit consideration. Government by order dated 16/10/2000 has fixed the lease rental at 10,000 with an escalation for all units. Before fixing the lease rentals, it was examined by the Revenue and Finance Department. Government has also considered the lease rentals fixed for similarly paced hydroelectric project in the neighborhood. As from the record, the decision to fix rentals was arrived after due consideration. The contention of Vijayalakshmi Hydropower Limited that as the company has invested a lot of money, it is left with no other alternative and hence signs the lease date at 10,000 per annum per acre cannot be given credence. In view of the above and in light of the fact that Honorable High Court both in writ petition and had declined to interfere the contract and fact that the lease rentals were fixed by the government after due consideration, Mr. Lakshmi had accepted the lease rental fixed by the government and entered into the agreement. There is no reason now to reconsider the terms of concluded. Hence, I find no merit in the representation. Same is rejected. Now, my lord.
Is there any stay of this?
No, my lord. No, my lord. There's no stay.
The writ petition, my lord, is taken up for hearing. Well, it was taken up.
I'll come back to you. I'll come back to you.
Yes,
yes, madam. Yes, madam. Now you, what else do you want to say?
My lord, when we read this order, if you may see, again, we have filed a rejoinder. In the rejoinder, I have produced Annexure B, which is on page 16. It's the letter dated January 31st, 2012, which was referred in this government order. The last para, we would like to inform you that we will abide by that. So, again, reiterating what is said in the government order, they had, again, in 2012 also, they had accepted at 10,000 and given this letter.
This letter is after the order of the High Court.
No, my lord. This was in 2012, January 31st, 2012. Whereas the High Court order was on 11th September 2012. This letter is prior to the High Court order. High Court writ petition is dated 11th September 2012, which is Annexure M, page 105. Prior to that also, they had written this letter, my lord.
Yes, yes. So it was earlier. It was earlier.
Yes, my lord. It was on January 31st, 2012, High Court order. And my lord, the main thing is it refers to the same Chikkamalagudu Gram Survey 138, which is same which I referred in the lease deed. Unit 2, Unit 3, it was the same area. It is not some other area. It is the same area. You may see it is there in the lease 2, Unit 2 and Unit 3 of the 2 lease deeds. The area is survey number, just the survey number 138, which you can find it in page 47, where it says that 14 guntas comprise of survey number 138 in the village Chikkamalagudu, Taluk Malavalli district, Mandya for unit. They have said in that all the units are in these areas. They are aware of these units which are pertaining. They were all fully aware that 10,000 rupees was the rent to be paid. Till today, they are not paying me my rent. They are producing power. They are getting money. There is no way power has stopped. It is not something that has been stopped.
Now your statutory note, yes, your statutory notice has been served.
Yes, my lord. The statutory notice has been served, my lord, which is in my annexure with the copy, which is annexure R1, page 140, R1. And the postal acknowledgement card is also on page 148, my lord. 149, I apologize. 149. Thereafter, I have given annexures. At the time, this writ petition, I mean, this company petition, apologies, was filed in 2016. Till as of today, the amount has gone up to nearly 1 crore. It has become with interest. At the date of filing, my amount was 42 lakhs.
Now, have they replied to this notice?
No, they have not replied to this notice.
Now, the amount mentioned in the statutory notice as dues is how much?
42 lakhs 56,000.
Which para?
No, accordingly, no, my lord. This is in the page 148.
Yes.
Accordingly, we can call upon you to pay 17 lakhs 57,402 towards rent for the period from 2009-10 to 2013 to 14, along with interest, which is 11 lakhs 93,957. So
Just 1 minute. Just 1 minute.
Yes, ma'am.
Yes. Now, let us see. We'll hear him and then we'll proceed.
Yes,
yes,
my lord.
yes. Respondent.
Lord, my lord saw the agreement, my lord, at annexure R2.
Yes.
Lord, at page 26. My lord also read clause 2A of that agreement, my lord, which originally, my lord, 1,000 per annum, my lord, was the nominal amount fixed. Now, my lord, this agreement is dated 3rd of April 1996. My lord, pursuant to this agreement, my lord, I have put in a lot of machineries and a lot of equipment at site. Now, my lord, thereafter in the year 2000, my lord, they suddenly, my lord, issued this lease deed, increasing the rent at 10,000 per annum. May I request your lordship to kindly take, my lord, annexure R6 at page 41. My lord, immediately after receipt of those, my lord, lease documents where the enhanced amount of 10,000 was mentioned, my lord, I have immediately issued this communication on 22nd May 2001.
No, this annexure R2 is signed by you, isn't it?
My lord, annexure R2 was originally entered into with 1 high temp furnaces. Now, my lord, annexure R3 and 4 and 5, my lord, are documents by virtue of which, my lord, this MOU has been transferred to, my lord, the respondent before your lordship. And, my lord, annexure R4 is the document by virtue of which the government accepts the transfer. Therefore, the terms of MOU has been transferred in favor of the respondent.
So that is not in dispute.
That is not in dispute. My lord, when I received, my lord, this lease deeds in the year 2000, after a lapse of nearly 4 years, my lord, I issued the communication dated 22 May 2001, annexure R6, your lordship will find. My lord,
just take me to the order of transfer of these terms.
Yes, my lord. My lord, may kindly take, my lord, annexure R3. My lord, R3 is the document issued by the original, my lord, agreement holder to the Secretary Energy Department. My lord, page 36. My lord got it. My lord, statement of objections, page 36.
Yes.
My lord, in in the first paragraph, the agreement is referred to. In this connection, we would like to inform you that Memorandum of Articles of Association does not provide for the generation of power and also for the conduct of efficient power of management. We have formed an independent company with the same promoter in the style of Vijayalakshmi Hydropower Limited Incorporated under the Companies Act so and so. Now, my lord, the next document at Annexure R4, my lord, is issued by the Secretary Government Department of Energy on 13/3/1997.
Yes.
My lord, the first paragraph, the agreement is referred to and the communication is referred to. The second paragraph, in this regard, I am direct to convey that government has taken note about the formation of the new company for implementation of the above project, and the agreement already executed between the government of Karnataka and High-Time Furnaces is treated as amended and modified in favor of the new company, Mrs. Vijayalakshmi Hydropower.
Yes.
Now, my lord, Annexure R5, my lord, dated 11/8/1999. My lord got it, my lord, at page 39. My lord, this letter in the month of August 1999, I write to the chief engineer. My lords, may kindly take, my lord, the last paragraph of page 39.
Yes.
In the absence of clear demarcation between the irrigation land and private land, the extent area of irrigation land required had not been mentioned in our request letter. However, we have approached respective tahsildars for survey of the land so that the private land can be purchased from private owners. So the next page, my lord, details of, my lord, the units are mentioned. We certify that we will be constructing our site offices, stores on the land taken lease from you. We are planning. You are requested to approve the lease at an early date so that we can complete financial tie-up and take up the construction of power project. Now, my lord, in the year 2000, they issue these three lease documents. Immediately after receipt, I issue, my lord, Annexure R6 on 22nd of May 2001. Page 41 of my statement of objections, please.
No, but as per Annexure R4,
yes, my lord.
It has been made over to Vijayalakshmi Hydropower on same terms.
Same terms, my lord, same terms. The original terms of the agreement, my lord, was, my lord, the nominal rate of 1,000 per year.
Or 10,000.
No, my lord, that amount of 10,000 is not mentioned. They say, my lord,
Or
page 28, subclause 2A. The government at a nominal amount of rupees 1,000 per annum or such annual lease amount as the government may determine from time to time. It doesn't mention 10,000. Under the impression, my lord, that a nominal amount of rupees 1,000 per annum, my lord, I enter into this agreement. Now the increase amount in the year 2000 is suddenly from 1,000 per annum to 10,000 per acre. Therefore, my lord, I immediately write Annexure R6.
So where do you get the 10,000? Once again, you just take
10,000, my lord, comes in the lease deed which my learned friend has produced along with the company petition at Annexure D, my lord. Annexure D, page 44.
That lease deed is signed between?
Both the
Between,
parties.
the petitioner, between the government and the respondent. My lord, my first case is, my lord, the petitioner does not have any locus. My lord, I have
No,
been...
that will come. No, that will come to.
Yes,
now, the lease deeds are signed by whom?
My lord, the governor of Karnataka and, my lord, the respondent before your lordship.
Then how have you signed the lease deed?
My lord, that is why, my lord, may kindly take Annexure R6, my lord.
No, but that is a different dispute. That
yes, my lord. My lord, that is why I am coming to that. My lord, Annexure, after, my lord, Annexure D lease deed, my lord, saw, I issue this communication at Annexure R6, 22nd May 2001.
No, but that dispute is different. You cannot
my entire case is, my lord, my entire case is that this entire amount I am disputing. There is an existing dispute pending. My representation at Annexure R6 and, my lord, subsequent representations, which I will show, my lord, is produced along with the company petitions, was kept pending by the government, my lord, up to 2017. In 2017, they reject my representation. I challenged it before the High Court, saying that, my lord, with an understanding, I enter into an agreement and you cannot unilaterally change the terms of the contract. Now, my lord, that is pending adjudication before this honorable.
Is there a stay? Is there a stay in that?
My lord, there is
No,
no.
my lord, no, my
But
lord.
my submission is, my lord, the amount claim under my lord, this is not a suit for recovery of money.
No,
My lord,
that may be so.
insofar
That
as
may
the
be so.
debt is concerned, my lord, this is not an admitted debt. I am disputing this debt. My lord, that dispute is pending adjudication. Irrespective of whether, my lord, there is stay or not, at the end of the day, the admitted fact is that the amount claimed under the company petition, my lord, isn't disputed.
Yes.
My lord, may kindly
I'll
see annexure R6 as page 41.
I'll consider that.
My lord, the second submission, my lord, is, my lord, annexure two representations. Once again, my lord, what I'm trying to show, my lord, is that there has been continuous representation on my behalf to the government of Karnataka. My lords are there, my lord.
We'll send word.
My lords, can you hear me, my lord?
Yes, yes.
My lord, what I'm trying to demonstrate before your lordship, my lord, is that, my lord, right from the year 2000 till, my lord, 2013, I have issued multiple representation to the government, my lord, to consider reduction of rent. Now, my lord, that representation is rejected in 2017, and my lord, I challenge that petition. That's a separate action, my lord. I am not bringing it. What I'm trying to submit, my lord, is that, my lord, there is an existing dispute in relation to the, my lord, amounts mentioned in the company petition. Irrespective of, my lord, if there is a stay or not, my lords are well aware, my lord, the provisions of section 433, which, my lord, the learned friend has invoked. My lord, it cannot be a provision for recovery of money. There is an existing claim, but, my lord, that claim is disputed. My representation, my lord, if it was earlier rejected, my lord, a ground, my lord, for the allowing of this company petition could have been made. But, my lord, my representation is rejected in 2017 after filing of this company petition. That is, my lord, understanding for this honorable court.
Correct. There's only one point. Now, till there is any decision taken, you
Yes,
are bound to pay what is under the lease deed.
Lord, in fact, the earlier lease amount, my lord, that I have paid, my lord, is paid in the writ appeal, my lord, because based on direction of court, my lord, I have paid it in the writ appeal. No matter, I am still disputing that amount because what had originally happened, my lord, from 1996 till 2000, my lord, I have put in a lot of machinery. Suddenly they increase the rent. Therefore,
That's
I
a different matter.
and it is also my case before the coordinated bench that, my lord, the agreement was signed under duress. My lord, few decisions, my lord, if I may place on record, my lord.
You can send it.
My lord, I have filed my list of authorities, my lord, on before this honorable court, filed by respondent. My lord, few decisions, if your lordship permits, I'll cite them.
We will go through it. Prima facie, I am of the view that till the dispute is finally decided,
Yes,
whatever is admitted as per the lease deed will have to be paid. Now there is no dispute.
Even that, my lord, my lord, my only submission is, my lord, can that order be passed in a provision under section 433? Because this is not a claim for recovery of money.
So that may be so, but there is a debt, there is an agreement, you are bound by it.
It is not an
So far as
disputed debt.
No, that we'll see, that I'll consider. Now, so far as the dispute that you have raised, it's only as to whether it has to be reduced from 10,000 to 1,000.
If it is reduced, my lord, my entire rent that I am liable to pay will also
That's
reduce.
a different matter. That's a different matter. But
It will
till
also
then,
reduce, my lord. Therefore, I will not be liable to pay them any money.
no, that you cannot say. That is only at
He's
the
enjoying my property and doesn't want to pay
Just
me.
wait, madam. Just wait. When the court is with you, you must keep quiet.
I apologize.
Now that I'll look into the authorities placed by you, but I am saying prima facie that once the lease deed amount is at 10,000, till your defense is adjudicated, that amount is the admitted amount, unless there was a stay of that. And that is the
if I may
court
make
has,
one submission, my lord.
yes,
My lord,
yes,
what I will do, my lord, before your lordship passes any order, my
yes.
lord, today itself I will move the writ petition, my lord. I will try to get some order there.
But we are not going to wait for that. That you cannot. We'll defer advertisement. I will.
Lord,
We'll
I am,
admit,
my
we'll
lord,
admit
I am,
it and defer,
it is my
defer
humble
advertisement.
submission before your lordship, my lord, that if my lord, if my writ petition is allowed, my lord, the
No, that's a
entire
different
amount
matter.
I have already paid in excess to them, my lord.
No, that is a different matter. Writ petition being allowed is will only be adjustment. But I am not inclined to buy the argument of dispute relating to this must wait and winding up proceedings must wait till conclusion of writ. That is a different matter. I am not inclined to accept that argument. I'll consider it. I'll consider.
The entire, my lord, argument is that, my lord, I owe them some money, and they admit the fact that, my lord, I am a going concern, and my lord, I am making a lot of profits, my lord, and my lord, the entire petition government seems to have been made seeking recovery of, my lord, the dues that is made.
No, that is so. The courts have also held that refusal to pay despite having sufficient means would
Yes,
also
my
be.
refusal to pay, my lord, I understand, my lord, but this refusal is because, my lord, there is an existing dispute.
No, that dispute, there is no stay of the contractual terms. You're a party to a contract unless the contract is set aside, and that too set aside where by in the jurisdiction. How the court can enter into a dispute relating to a contract? That is the precise question that was voiced by the court in the earlier occasion.
What I have also sought, my lord, is the unilateral decision of the government, my lord, subsequently altering the terms of contract. My lord, if terms of contract are to be adhered to, my lord, the original agreement of 1996 clearly says, my lord, 1,000, my lord, will be the nominal rent per annum.
Then
And
how did you enter?
period of lease is 30 years.
How did you enter into the lease deed? You have signed the lease deed.
My lord, under duress, I have immediately issued that communication.
That is before the civil court, sir.
My lord, that is why, my lord, I am saying, my lord, I have questioned that lease deed as well as the terms therein before this honorable court in a separate petition.
That is before a wrong forum.
Can the means of, my lord,
no, you cannot. How can you challenge a contract before the writ court?
Not the contract. It is the decision of the government. Admittedly, the contract is entered into between the government and me, my lord.
That
the terms of the contract is changed subsequently. It is not, my lord, that the new contract is entered into. Therefore, that decision I have challenged.
That I'll consider. Now, what is the authority that you rely on?
I have filed my list of authorities, my lord.
What is list of authorities? Yes.
My lord, the first decision, my lord, my lords are aware, my lord, Divya Export Enterprises.
Yes.
My lord, may I request your lordship to kindly take para 16, my lord, of the judgment, my lord, at ink page 7, please, my lord. Where, my lord, the court is interpreted, my lord, purpose of section 433 under the Companies Act.
Paragraph?
Paragraph 16, my lord. It's the last two lines in page 7. Starts from last two lines in page 7, my lord, on the right hand side.
Yes.
Under section 433E of the Companies Act, a company may be wound up by court if a company is unable to pay its debts. The provision vests a discretion in court, but discretion has to be exercised in the manner any other judicial discretion is to be exercised. It is a judicial power warranting a proper exercise. Para 17. If the respondent company pleads a defense in good faith and put forth substantial case against the petitioner's claim, the claim for winding up will be rejected. A mere assertion of a debt payable by the respondent company is not sufficient to attract the discretion of the court in favor of the petitioner. The principle governing the exercise of court's discretion is extracted in the decision of division bench of so and so. Lord, next page at page 8, after, my lord, the reference. The word caution against invoking court's jurisdiction to pressure a government are found in the decision of so and so. It is well settled that a winding up petition is not the legitimate means of seeking to enforce payment of a debt which is bona fide disputed by the company. A petition presented is ostensibly for a winding up order, but really to exercise pressure will be dismissed and under circumstances may be stigmatized as a scandalous abuse of the process of the court. At one time, petitions founded on the disputed debt were directed to stand over till the debt was established by action. If, however, there was no reason to believe that the debt is, if established, would not be paid, the petition was dismissed. The modern practice has been to dismiss such petitions. But of course, if the debt is not disputed on some substantial ground, the court may decide it on the petition and make the order. The test applied by the Supreme Court in the above case was whether the non-payment of the claim by the respondent company was a cloak to hide its inability to pay its debts. When a prima facie is made out, the petitioner, the respondent may put forth a substantial defense against it. If such defense is bona fide, court's discretion will be to dismiss the petition. Now, my lord, they refer to Madhusudan Gorandas, my lord, which is also, my lord, a good principle on the point. The principle on which the court acts are first that the defense of the company is in good faith, and one of substance. Secondly, the defense is likely to succeed in point of law, and thirdly, the company adduces prima facie proof of the facts on which the defense depends. When can a dispute be termed as a bona fide one? When it is to be treated as substantial. These questions are difficult of a precise answer in abstract. There are in the realm of facts. Each case would churn out different answers, but the court can refer to certain tests envisaged in similar circumstances, though not exactly under the provisions of the Company Act. In case of suit filed under Section 37 of the Code of Civil Procedure, it has to seek leave of the court to defend against it. It has been held that if the defense could be honest and bona fide, leave should be granted. A decision whether the defense plead is bona fide or honest at the initial stage of a suit can only be hazardous, but still, the court is called upon to apply its judicial mind of the question. Similarly, in the situation when the respondent company is asked to show cause against a winding up order at the initial stage, the respondent here has to show cause as to why the petition should be advertised. Such an advertisement has adverse effect on the reputation of the company, and therefore it is given an opportunity to show cause against ordering the advertisement. Therefore, whenever the respondent company comes forward and sets forth its defense, this court has to examine the nature of respective cases pleaded by the parties, and if prima facie case is made out by the petitioner, the respondent should shoulder the onus of disproving it by showing that the defense is in good faith and one of substance, and it is likely to succeed in a point of law. The guidance to find out whether the defense is bona fide, so and so. Lord, para 24. I'm sorry, my lord, para 27 at page 11. The respondent has produced its balance sheet as per Annexure R22 for the year 31st March 1989. This shows that it made a profit of rupees so and so after providing for depreciation and taxation. Its current assets, loans, and advances are shown to be so and so. Then the current nets are so and so. On the assets of the company and commercial solvency cannot be doubted. This aspect is one of the circumstances to be read in favor of the respondent while considering the objections put forth by the company against the petitioner. My lord, I am a going concern. In the statement of objections, my lord, I have clearly mentioned that I am making profits. Can this petition, my lord, be used as a means of recovery of money? Is, my lord, my humble submission. My lord, the next judgment, my lords will find at page 12. My lord, in the case of Mediquip Systems Private Limited versus Proxima Medical System, my lord, AIR 2005 SC 4175. I request your lordship to kindly take, my lord, para 15 of the judgment at ink page 14, please, my lord. Lord, para 15, my lord, is about dispute. I will not read it again, my lord, that there is an existing dispute. Para 18, if your lordship sees, at the very same page. This court in Catanov decisions has held that an order under section 433 of the Companies Act is discretionary. There must be a debt due and the company must be unable to pay the same. The debt under this section must be determined for a definite sum of money payable immediately or at a future date, and that the inability referred to in its expression unable to pay its debts in section 433 should be taken in the commercial sense, and that the machinery for winding up will not be allowed to be utilized merely as a means of realizing debts from a company. The respondent is not a creditor and the appellant is not a debtor insofar as so much money. The defense raised by the appellant is substantial one and not mere moonshine, which is to be finally adjudicated upon merits before the appropriate forum. Therefore, my lord, my humble submissions, my lord, para 25, my lord, sees next page as page 15. The rules as regard disposal of binding of petition based on disputed claims are thus stated by this court in so and so. This court has held that if the debt is bona fide, disputed, and the defense is substantial one, the court will not wind up the company. The principle on which the court acts are that the defense of the company is in good faith, the defense is likely to succeed at point of. The company adduces prima facie proof of the facts on which the defense defends. In view of the judgment now pled, entitled to refund so and so. The para 20, in view of all this, there is no prima facie dispute as to debt. Lord, my humble submission before your lordship is, my lord, there is no dispute at all by the petitioner that, my lord, I am unable to pay my debts. In fact, the petitioner in their submission itself stated that, my lord, I am making profits. It is not, my lord, a company, my lord, which has to bear, my lord, such outcome, my lord, where its reputation is also ruined. The amount claimed by the petitioner, my lord, I am bona fidely disputing it. Therefore, my lord, means of section 433 should not be used to embarrass me. That is my only humble submission before your lordship. If, my lord, if the petitioner is justified in claiming that money, my lord, they are always left to, my lord, approaching the court of law in appropriate proceedings seeking recovery of money. Not under section 433 of, my lord, the Companies Act. My lord, the next, my lord, judgment, if your lordship sees, my lord, at page 16, my lord, IBA Healthcare Private Limited. IBA. Lord, para page 16, my lord, 2010 10 SCC 553.
Page?
Page 16, my lord, the judgment starts.
Yes.
The relevant portion, my lord, will find at page, my lord, 26. My lord, this judgment, I am using it to submit before your lordship, my lord, that I am commercially solvent. Page 26, my lord, internal page 26. Para 24. The appellant company raised the contention that it is commercially solvent, and in such a situation, the question may arise that a factum of commercial solvency as such would be sufficient to reject the petition for winding up unless substantial ground for its rejections are made out. A determination of examination of a company's insolvency may be a useful aid in deciding whether the refusal to pay is a result of bona fide dispute as to liability or whether it reflects its inability to pay. In such a situation, solvency is relevant, not as a separate ground. If there is no dispute as to the company's liability, the solvency of the company might not constitute a standalone ground for setting aside a notice of dispute. Meaning thereby, if a debt is undisputably owing, then it has to be paid. If the company refuses to pay on no genuine and substantial ground, it should not be able to avoid the statutory demand. Yes, the law should be allowed to proceed, and if the demand is not met and the application of liquidation is filed under section 439 in client's presumption under section 434 that the company is unable to pay its debt, the law should take its own course, and the company, of course, will have opportunity on liquidation of so and so. Para 25. An examination of company's solvency must be useful aid in determining whether the refusal to pay is a result of bona fide dispute as to the liability or whether it reflects its inability to pay. My lord, I am submitting before your lordship that, my lord, I am not in a position where, my lord, I am saying I am not able to pay. I am making profits. Of course, if there is no dispute as to the company's liability, it is difficult to hold that the company should be able to pay merely on the merely by proving that it is able to pay its debts. The last few lines of the same prayer. In other words, commercial solvency can be seen as relevant so as to whether there was a dispute as to the debt, not as a ground in itself. That means it cannot be characterized as a standalone ground. Therefore, my lord, by using this judgment, my lord, I am submitting before your lordship that, my lord, an admitted fact before your lordship, which, my lord, the petitioner also admits that I am a profit-making company, and therefore, my lord, the means of section 433 cannot be used, my lord, to pressurize me into paying that money, especially when, my lord, the dispute is pending existence. My lord, the next judgment, my lord, is, my lord, a division bench of Calcutta High Court, my lord, at page 30. In the case of Ram Kumar Agarwal and another versus Buxar Oil Rice Mill and another. The relevant portion of the judgment, my lord, will find, my lord, at page 6, at para 16, my lord, at page 32.
Yes.
The decisions relied upon, my lord, got it, my lord?
Yes, yes.
The decisions relied upon do not establish that the court will make a winding up order on the petition of a person who claims to be a creditor of the company without satisfying itself that the petitioner is in fact such a creditor. The court has the power and the duty to see that the machinery of winding up is set in motion only by a person who is entitled to present a winding up petition. The court will dismiss a winding up petition by a person claiming to be a creditor of the company. The petitioner does not the petitioner does not affirmatively establish that he is in fact such a creditor. The authorities relied upon show that the bankruptcy and winding up courts have large power to prove test, assuming that the winding up court has the power to disallow the proof of the petitioner creditor only if it is satisfied that in fact there is no debt due to him. It does not follow the court will make a winding up order at the instance of a person claiming to be a creditor of the company if he fails to satisfy the court that he is such a creditor. The appellants claim to present the winding up petition on the ground that there are trustees holders of debentures appointed by the debenture trustee. Meaning subsection 20. There is a serious dispute as to validity of the debentures and debentures trustees and as to whether the appellants are creditors of the company as well. The dispute cannot be resolved on the affidavit. In the circumstances, the winding up order ought not to be made. The appellants will be at liberty to enforce their rights by other means. The opinion expressed in this judgment and the judgment of the learned trial judge must not be taken. My lord, as I submitted earlier, my lord, the agreement, the lease agreement, my lord, which is under dispute, my lord, is entered into between the governor of Karnataka and, my lord, the respondent. It is also my case, my lord, that the petitioner has no locus to file this petition. Under what portion of the lease deed, my lord, or the original agreement of the year 1996 does entitle the petitioner to present this petition before your lordship, so as to prove that, my lord, it is the creditor? My lord, under similar circumstances, my lord, at page 33 also, my lord, on the very same point. My lord, the next judgment, my lord, is, my lord, on the ground of limitation. It is also my defense, my lord, if the amount was due from the year 2000. The company petition is filed in the year 2016. Because, my lord, the debt is barred by time and the petitioner, my lord, or the government, my lord, cannot go before the appropriate court to seek recovery of money, my lord, as means of pressurizing a petition under section 433 is filed. May I request your lordship to kindly take, my lord, page 37, my lord, of my list of authorities. Para 19. I'm sorry, my lord, I could not get this original order, therefore, my lord, I have produced this. Para 19, my lord, got it?
Yes.
For application of section 14(1), it is necessary to show that civil proceedings which were taken earlier by the petitioner were relating to the same matter in issue and the said matter was prosecuted in good faith in a court which for the defect of jurisdiction or otherwise cause like nature was unable to entertain it. A company petition for winding up in which ultimately the petitioner may get the amount due to him or some amount on pro rata basis does not necessarily mean that the matter in issue will be the same as in a suit for recovery of amount had it been filed. In order to ascertain whether the claim of petitioner is barred by time or not, what is to be considered is whether the petitioner can institute a suit for recovery of the amount claimed to be due from the respondent to the petitioner. In the case of so-and-so, the High Court had refused to interfere on the ground that there was another remedy by way of suit in that matter, and therefore it was held that in such a matter, the conditions necessary under Section 14 of the Limitation Act were not satisfied. Lord, one was to file a suit for recovery of money, amount allegedly due to the petitioner, and the other to file a winding up petition. No limitation is provided for winding up petition under Section 433 of the Companies Act. But filing a winding up petition will not save the limitation for filing the suit of the facts of the claim the petition for recovery barred by time. My lord, then, my lord, at para 27, eventually, my lord, the court holds because it is barred by time, my lord, the provisions of section 433 has been invoked. Therefore, my lord, the petition is not maintainable. As a means to overcome, my lord, the stale claim, my lord, provisions of 433 cannot be used. Is, my lord, the law laid down as this in this judgment? My lord, in fact, my lord, this honorable court also, my lord, the coordinated bench of this honorable court, my lord, under a similar situation. This esteem estate, which is that name?
Yes.
My lord, may I request, my lord, the judgment starts at page 47, my lord, in company petition number 211 of 2011. My lord, may I request your lordship to kindly take page 57, my lord. Ink page 57, please, my lord. Para 4.3. Lord, why I'm reading this, my lord, is to show, my lord, what exactly is the purpose of 433 and what is adjudicated for this judgment. He would also contend that no presumption can be drawn under 434(1)(a) that respondent company is unable to pay its debt for being ordered to be wound up unless the petitioner company has pleaded and proved to the satisfaction of the court that in facts of the case such a situation has arisen, namely the respondent company is unable to pay its debts by taking into account the contingent or prospective liabilities of the respondent company. He draws the attention of the court in the instant case. Petitioner has neither pleaded nor proved that these aspects as such petitioner is not entitled for the relief sought for. My lord, after discussing the factual matrix, my lord, the findings, my lord, will find, my lord, starting at page 67. At page, my lord, I'm sorry, much. Page 81, please, my lord. Just one paragraph, my lord, and I will conclude this one. Page 81, my lord, para 22. Section 433 of the Company Act enables this court to wind up a company if it is unable to pay its debts. Said exercise of power is discretionary and has to be judicial. If the respondents plead putting for defense that the claim of petitioner is genuinely disputed, and if it can be construed as a bona fide dispute, then this court would be in loath in exercising the said discretion for ordering winding up the company. In light of what is stated above, let me examine the facts. And then point number 2, since the dispute, my lord, is examined. And also, my lord, at page 89-27, a reference is made to another proceedings, my lord, where the disputed amount is being adjudicated. And therefore, my lord, the company petition was dismissed on the ground of an existing dispute. Therefore, my lord, my humble submission before your lordship, my lord, is that first and foremost, my lord, I am commercially solvent. I am not a company, my lord, that is unable to pay its debts. Secondly, my lord, if, my lord, the petitioner is seeking recovery of money under these petitions, my lord, because 433 cannot be invoked, my lord, against a company which is commercially solvent. My lord, if it is seeking recovery of money, my lord, there is separate forum set forth for that, and the petitioner may exercise its jurisdiction. Thirdly, my lord, that dispute of the amount which is claimed under the petition, my lord, is pending. It is being adjudicated. Therefore, my lord, under these circumstances, my respectful submission before your lordship, my lord, is that petition under section 433 is not maintainable. My lord may kindly consider these submissions.
Pass it over and I dictate it in court.
Yes.
The court officer will see. That time I'll give you 10 minutes just before I start dictating to make your point. And the court officer will intimate the time on the chat box. Let me see how the list is.
Yes, my lord. And my lord, one submission, I have not received even one of his citation. He's not given me anything whatever he has referred.
I think it was served on them.
It was not served on us, my lord. He's gone into so much.
Email is what I'm told. I'm sorry.
No,
I consider,
no.
I consider it.
And I will send my submission to the court officer, my lord, my citation. I have one citation which I will send it to the court office.
Send it across, send it across.
Yes, my lord, it'll be sent across. Much obliged.
Grateful. Please.
This I'll pass over with the understanding that I will not read it as part heard though. If I finish, I want to finish it. And let's see, there may be some changes next week. So if it continues, then we'll continue from where we left off. Because I don't want to then proceed.
Have it next week itself.
We'll relist it.
Release it next week.
Relist it.
I
Let
don't
us
want to
see.
take a lot of time at this.
No, it's correct. Now, no doubt we have entered into it, but it requires some deeper hearing. So we'll relist it next week. Relist the matter on 24. 24. Okay.
34.
The matter the first week of March, second week of March. Yes.
35.
The other side will not ready. Finally.
This is the matter in the week commencing from 7th of March.
Number 36.
My lord, I am appearing for respond, my lord.
6.
Yes, see, I'll pass over. If time permits, I will.
Obliged.
Yes.
Next to order seat number 1. Ravi Prakash.
My lords, I appear for the petitioner in this matter, my lords. It is on the office note, my lords.
Yes. The office put up a letter to the state forensic science.
I'm representing respondent, my lord.
It has come up before the court only with respect to the letter of the office regarding documents sent to FSL. Now
Please,
that will have it sent back to the registry and then returned to the respective parties.
Please, my lords.
The office has put up the letter dated 2/2/2022 received from the State Forensic Science Laboratory regarding further admitted signatures to be sent if available, and if are not available, same to be intimated to this office. It is noticed that this court, during the pendency of the proceedings, had to the handwriting expert for necessary opinion as per the order dated 24/4/2019. However, it is to be noticed. Next, it is also noticed that by order dated 27/6/2019, registry was directed to send admitted documents. The director, State Forensic Laboratory, Bengaluru. It is to be noticed that this court, by order dated 5/2/2021, while specifically referring to the dispute relating to the signature, as at para 9 observed that the said aspect is a matter left open to be established by way of inquiry before the arbitrator. And accordingly, disposed of the petition, referring them and has referred the matter for arbitration. By keeping open contentions of the parties. In light of the final order passed, the question of proceeding with an opinion on the disputed signature by the Forensic Science Laboratory does not arise, and accordingly, the registry to obtain back all other documents stated to the Forensic Science Laboratory as per the earlier orders passed by this court, and upon receiving the said documents back, same are to be given back to the respective parties. Represented by their counsel in the CM.
Please, my lord, sir. Much obliged.
Please, my lord.
I appear for the first and fifth respondent, your lordships. I pray for 2 weeks' time to file my objections in this case. I have just received the parawise comments.
Now, can you find it? Can you file it? Can you file it before the 23rd? Since you have the parawise, you file it before 23rd. We'll take it up on 23rd.
23rd, your lordships.
Because it's a covered, correct? It's a covered,
Yes.
it's covered. So I'm saying if you could file it by 23rd, then we'll dispose it off in terms of that order. The order that I passed,
Yes.
it's on the same point, same identical factual situation, we've disposed it off. So
Your
the
lordships,
filing.
two observations that I have made in the petition is that one thing is that the shipping bill is not produced, and the other thing is that there's no mention in the petition as such that the petitioner had filed his declaration in the shipping bill. That he would reap the benefits under Chapter 3.
So that we'll ask him to produce. That we'll ask him to produce
Yes.
by the next
Yes.
day. We'll
Yes.
ask him to produce. But
Yes.
your stand, you can place it. We'll look into it and then we'll proceed.
I'll try to, your lordships.
Try. Let us see. Right. It's the matter
Try
on.
to Delhi each time. The signature, etc. Your lordships. So, okay.
Let us see. We'll have it on 23rd. You try.
Yes, your lordships.
Yes. The Senior Council produces list of citations relied upon. Now, those two aspects you just look into. What?
Yes, your lordships.
Next.
annexure F onwards, and given the list with the values also. Produce any number of as a sample, but 200 bills of practice before the existing would be connected F and show this right at 93.
But they're saying at annexure F, they've given the list.
F, G, H, and U, four annexures. You can see it right away.
F, G, H, and U. So unless that is in dispute, that you find out from your officer. Annexure F, G, H, and U. So that you find out factually from your officers. They've given their list in those annexures. That you find out. They're saying they will produce it if required, but according to them, that is not in dispute. That factually you find out from your officers.
Yes, Your Lordship. I'll do that.
Mr. Raghuram, you just assist by giving whatever details so that they can in turn get instructions from their side. Let us see. This is the matter on 23rd.
Lordship,
23rd.
23rd, yes, sir.
In the same stage. Clarify their doubts beforehand so that if further clarification, they can get it so that we could proceed further.
Yes, sir.
Government advocate notice. Number 14, Mahadevan, Lata Shetty.
6 weeks. 6 weeks. 2, 3, 14.
What is the order that we have passed? So now so 6. So the same order in serial number 30. Yes.
Serial number 16. Serial number 16. ಇದು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ನೋಟಿಸ್ ಇಲ್ಲ ಸರ್ ಎಜಿ
In this matter, you will appear even for the state. So, respondent is Department of Collegiate Education. So you accept notice and you see if matter could be resolved without necessarily sending it to for inquiry. So they have said there is a claim. So just look into it. Land Council should given accepts notice for the respondent, sole respondent. Submits that inspections would be taken in this matter. This is the matter after 2 weeks.
21. Serial number 21.
Oh, this but you find out whether this is a society. So it says Society for Child and Women Empowerment. So whether it is a association or a state entity, you will have to find out. That is society is 16. Now this order that I passed was in serial number previous one.
16.
That, 16 is collegiate education.
Separate.
Now which is this collegiate education? That is 21. ಹಿಂದೆ ಯಾವ್ದಂತ ಬರ್ತಿದ್ದೀವಿ ಮತ್ತೆ ಯಾವುದು serial number ಅಂತ ಬರ್ತಿದ್ದೀನಿ ಡಿಕ್ಟೇಟ್ ಮಾಡಿ ಅದು 21. So that collegiate education is 21. So that order is passed in 21. Right there. Okay. Now the society is which matter?
16. Serial number 16.
Now serial number 16, the respondent is Society for Child and Women Empowerment. So just find out. You find out. Find out. Just see whether you can. The council. Find out. 16. Relist the matter. 24. Find out it is.
Four continuation. 4. Serial number 3. Serial number 3. Chandrasekhar K.
Just use the mic.
Application is submitted to coordinate bench of dishonorable court had refused. Investigation agency to question the sanction which was rejected by the competent authority. She can ask me for the judgment and pass on. Page number 7 minutes is points for consideration. Please, my lords, not quite challenge.
So it holds that you have no interest in, you cannot have legal interest in challenging.
I am not a aggrieved person to challenge the rejection of sanction. But my lords, against this order, they are filing. And also, section 17A is called in question for the division bench by way of public litigation in WP number 22809 of 2021. 22809.
2809 of
2021. That is next posted on 22nd of March for filing objection.
Oh, that's before the division bench.
Yes, it's a public interest regulation.
We were in Om Prakash Sharma's case, which is page 119 of Madhya Pradesh.
Page 100.
Certain guidelines have been laid down.
Page 119.
119.
Yes.
My lord, to recollect this case, my lords, where private complaint referred under 156(3) and investigation was not going on, how long can the court wait? Ultimately, the court holds that you can wait for a period of 60 or 90 days, depending on the offense, and this private complaint thereafter revives itself, you can go on with the matter. In that context, my lord, certain guidelines which were laid down, which included speedy investigation. Now, the relevant portion, my lordship would kindly see page 125, paragraph 8, my lords. Where perusal of chapter 12 of CRPC.
Paragraph 8.
Paragraph 8. Where perusal of chapter 12 of CRPC, which relates to investigation of offences, reveals that authority to conduct investigation is exclusively vested with the police. However, the magistrate is vested with limited role, which is of supervisory nature, to be sparingly exercised on occasions where police either fail to register an FIR or conducts investigation in improper manner. The legislature, while vesting the said power of investigation solely in the hands of police, was conscious of its possible misuse. As such, 156(3) was engrafted in chapter 12, conferring supervisory powers upon magistrate with a view to ensure free, fair, and expeditious investigation. These limited powers available to the magistrate are to cater to the following eventualities. 1. Failure of the police to register an FIR under section 154(1) and 3 CRPC. 2. Failure of the police to conduct free, fair, and expeditious investigation.
So far as one, it is completely correct.
Yes.
Because in effect, they were required to do. Second part is little extending.
That is where the guidelines come from. First part, it is clear, now we are very clear on the first aspect of it. They don't
No,
register.
and correct. So also in terms of interference also, since at the first instance, he ought to have registered the FIR. Not having done that only, you come to the court. So obviously, since there is an allegation that you did not register it, the power of supervision so as to ensure that it is proper in light of the allegation that they did not do it deliberately is definitely to be read into. The other one.
This is very interesting. Second aspect of it. Failure of police to conduct free, fair, and explicit investigation. Scheme of chapter 12 CRPC elicits an object behind vesting this limited supervisory power upon the magistrate is to ensure that the information regarding commission of cognizable offence received from any source does not go uninvestigated. The rationale behind this object is not far to see. A cognizable offence is serious enough to not only adversely affect the victim but also the society at large, and therefore it's a sovereign function of the state through the police to ensure that any cognizable offence, whenever and wherever committed, does not go unregistered and uninvestigated by police, untried by the competent court, and unpunished if found true. Thus, it is incumbent upon the magistrate under 156(3) CRPC to not only direct for registration of cognizable offence wherever it is found to be not registered by the police, but also to ensure that the investigation conducted by the police is fair, expeditious, and without any element of prejudice towards anyone, with the sole object of teaching the truth. The role of magistrate under 156(3) CRPC is thus of great significance. Prompt and appropriate exercise of powers under 156(3) CRPC not only brings succor to the victim, but also to the society at large by bringing the delinquent to the book and in the process instilling enough fear in the minds of the miscreants so as to dissuade them from indulging in delinquency again. My lords, then they go into the aspect of 210 and all that. And finally, my lords, at page 128 is the guidelines. Very first line, my lords, at page 128. My lords, you notice this court is thus compelled to lay down certain guidelines governing the exercise of their power under section 156(3), where such applications are either filed individually or along with complaint under section 200 CRPC. A, where application under 156(3) alleges non-registration of cognizant offense. My lords, 1, 2, 3, 4. Priyanka Srivatsa quoted what all that you could do. More importantly will be, my lords, near 4 capital B stats, my lords, where application under 156(3) CRPC reveals improper delayed investigation only. My lords, it's a question, my lords.
At Roman 4.
Roman 4 it just became a continuation of that, my lords. Roman 4
Yes, yes.
B. That should have been as a next paragraph. Some, I think,
In case application.
yes, my lords. Where application under 156(3) reveals improper delayed investigation only. 1. In case application under 156(3) relates to grievance of improper or delayed investigation after lodging of FIR, the magistrate should direct the police to submit report and thereafter pass appropriate remedial directions if the report submitted by the police discloses improper or delayed investigation. The magistrate, after passing such order, can also monitor the process of investigation to ensure that it reaches to its logical and lawful conclusion. However, while doing so, the magistrate should avoid stepping into the shoes of the investigating agency. The magistrate ought to assume only supervisory role. 2. In case a report requisition from police reveals the investigation is done with promptitude and in accordance with law, then the application that 156(3) should be dismissed by passing a short speaking order. 16. It's matter of common knowledge that application under 156(3) CRPC are kept pending for long, awaiting report of police. There are occasions, as in the case herein, where 156(3) application is filed along with section 200 CRPC complete, but only due to delay in processing 156(3) application, the complaint under 200 is kept pending for an unreasonable long time. To group this delay, it is further appropriate to lay down certain guidelines which are, though not exhaustive in character, but are enough to show the right path to be treaded. 16.1. The magistrate, while dealing with application, ought to keep in mind certain relevant factors which are as under. 1. The requirement of laying down a timeline for deciding proceedings where application under section 156(3) is filed along with the complaint under 200 would arise only in those cases where 156(3) application complaints of improper or delayed investigation, but not in cases under 156(3) relating exclusively to grievance of non-registration of a fair enough, only comes in that situation. How long they will take to register it. This because the grievance of non-registration of offences placed in application with 156(3) can be disposed of within 2 days of its receipt by directing police to lodge a FIR. 2. Turning to the grievance of improper or delayed investigation raised in application under section 156(3).
No, but this is in the practice of 156 being filed as a separate application. So
Both,
suppose,
both. Because my lords would have noticed in the previous page at para 16, it's matter of common knowledge application to 156 are kept pending for long awaiting report of police. Their occasion, as in the case herein, where 156 the application is filed along with 200.
that practice we don't follow here, isn't it?
ಈಗ ಮಾಡ್ತಿದ್ದಾರೆ.
We're doing.
Now we have started doing it because we have some recognition of an application being 156 the application by itself.
So along with the PCR and the 200, you file 156(3) separately.
Normally, my lords, it is part of your complaint.
Correct.
You just file a complaint.
Correct.
In that, when you request a court, you can request a court. The magistrate may exercise the powers under 156(3) and direct it to the police for the investigation. So, magistrate will have to look whether it's a case where he would refer it or he will proceed in taking cognizance. So, that's the option which the magistrate has. So, I, as a complainant, have to only file a complaint. I could only make a request. This is how it was. There's no need for any applications, XYZ. But now, because of the practice that has come from North Melons, they don't file a complaint. They merely file an application under 156.
Only.
Only an application under 156(3). If my lord should see Priyanka Srivatsa's case, that's exactly what happened.
No, but here also they're doing this now.
Now they have started developing that.
As a practice.
With the consent fee, where there's a delayed investigation, I tell them to file an application 156(3). Now it is recognized for improper investigation. You don't need to file a private complaint. Merely file an application under 156(3). Point out to the court that you have powers to supervise and monitor. In view of that, exercise the powers and pass appropriate directions. And that has been recognized now even in Supreme Court.
So those applications could be relating to improper exercise or even non-registration.
It could be even non-registration of an application 156(3) or non-registration, or an application under 156(3) asking for an improper. Because as soon as I file it as a complaint, the risk that I may run is
The court may take cognizance and go under.
Where to discharge the burden from. So to avoid that situation, now when it's recognized that you can file an application under 156(3), safer manner that I file an application under 156(3) than a complaint under 200.
Yes.
Because we were at 129(2), Madam, studying the grievance of improper or delayed investigation raised in application under 156(3). It is seen that as and when report from police is requested by magistrate on application under 156(3), complaining about improper or delayed investigation, it is presumed that the case being dealt is one where FIR has already been lodged and process of investigation is pending. Thus, the bar contained in 210(1) comes into operation, compelling the magistrate to put on hold the inquiry trial if commenced pursuant to complaint under 200. So here, my lords, the court equates this application to a complaint under 200. Because, my lords, the bar under 210, if you see, my lords, the bar is to a complaint. To keep the complaint on hold, let the investigation get over. So even this application which they are filing under 156(3), now the court equates it to a complaint and says the bar kicks in. Then, my lords, in this matter, the complaint under 200 CRPC suffers a state of suspended animation. It is at this stage that delay takes place, not only due to laxity on the part of the police to submit report requisitioned by magistrate under 156(3) in a pending investigation, but also due to leniency shown by the magistrate in liberally granting time to the police, resulting into the complaint under section 200 suffering stalemate.
No, when it is already being investigated, and suppose he doesn't, now instead of coming under 200, 156(3) will be the appropriate remedy.
Appropriate one. But when we come under 156(3), my respectful submission, it should not be equated to 200.
Correct. Because it's only for a limited, that though it is, he is investigating it, he is not taking it.
It's registered, he is not investigating it properly or delayed investigation. So I need appropriate directions directly into it. It should be only in that. So this first A, my lords, when they say, probably may not be right in saying 156(3) is 200. No.
Correct.
Pertinently, the bar contained in 210 CRPC is based on following fundamental assumptions that primacy and preference is to be given to police case over proceedings originating from a complaint under section 200 CRPC. 2. The preference and primacy given to a police case is in turn based on the assumption that police, being part and parcel of state, performs the sovereign function of crime investigation in a fair, reasonable, and expeditious manner. The police, by performing the sovereign function, is presumed to act honestly. The presumption of police being honest and diligent during crime investigation is rebuttable. The following standards of morality in society have rendered the all-important element of probity either missing or suffering a considerable value erosion. As such, the presumptive element in section 210 of police case gets primacy and preference over complaint case needs revisit. If the mandate of 210 CRPC is such that it prohibits complaint under 200 CRPC to be proceeded with during pending investigation by police for the same offense and accused. The problem arises when investigation is kept pending for unreasonable long time and it is not completed even on expiry of 60 and 90 days as prescribed in section 167 CRPC or for any other longer period as prescribed under certain special penal statutes. So the equating of mandatory bail has come here and trying to fix a time to complete the investigation. This indefinite delay in investigation paralyzes the complaint under section 200 CRPC, dissuading the magistrate from taking steps under chapter 15 and 16 of CRPC for cognizance. This problem deserves scrutiny from another viewpoint. The remedy in shape of complaint under chapter 15 and 16 of CRPC is available exclusively to a victim. The concept of victim came to be statutorily recognized in CRPC since 31/12/2009 Act 5 methods, where a lot of amendments took place. Whereas section 210 is part of CRPC since inception, that is 1973. Thus the lawmakers, while engrafting section 210, had no occasion to take into account its repercussions for victims. More so, the remedy of complaint in chapter 15 and 16 of CRPC is a statutory avenue made available to a victim or complainant. This avenue may not have primacy or preference over police case, but the same cannot be allowed to be rendered infructuous at the altar of section 210 CRPC, especially in cases where police fail to conduct investigation within a reasonable time. At this juncture, another issue which needs addressing as to what should be deemed to be a reasonable time for conducting of investigation. Indisputably, CRPC does not lay down any time frame for conducting of investigation except stipulating in section 173(1) that every investigation under chapter 12 shall be completed without unnecessary delay. Non-prescription of a time frame for conclusion of investigation is understandable. With innumerable variable factors involved in the process of investigation, which is complex in nature, the law has left the field open for police to initiate, conduct, and conclude investigation in an unfettered environment with the ultimate object of reaching the truth without fear, favor, affection, or ill will. Pertinently, there are very few investigations that are conducted and concluded without fear, favor, affection, or ill will. Therefore, this court cannot turn a blind eye towards this stark reality by conveniently hiding behind technicalities of law. This court is thus impelled to tread on an uncharted path to secure the ends of justice for protecting the interest of complainant or victim. Crime investigation is one of the primary duties of police, though in recent times, energy and time of police officers appear to be diverted more towards the ancillary duties of maintaining law and order and VIP duty. Since crime investigation is more arduous than the ancillary duties, the police tend to tread the convenient path. This dangerous tendency developing the police is at the cost of quality of crime investigation. More so, the police reforms as directed by the Apex Code in the case of Prakash Singh versus Union of India 2006, decided 15 years back, are still to see the light of the day. The lawmakers, while enacting CRPC, appear to be aware of the possibility of commission committed by the police during investigation. Therefore, the provision of Section 167 CRPC was engrafted where bail can be claimed as a matter of right in case of failure of police to complete investigation and submit charge sheet within 60 or 90 days or any longer period prescribed. The lawmakers realizing the importance of personal liberty, and so it's a last sentence there in that paragraph. Thus, if not in express terms, but impliedly, it can be gathered that lawmakers prescribed a maximum period of 60/90 days within which the police is expected to complete the investigation, starting from the stage of 154 to 169 or 173 CRPC.
Or further time as may be under the special statute.
Special statute. And if they're not able to do it, then they will have to report why they're not able to do it. That's the reason, my lords, it is more in lines of guidelines, not strictly. There may be some cases, my lords, they may be genuine. In that, the court will look into it. Yes, in this case, you can take this much longer to complete the investigation. There has to be some kind of a time.
The reporting is to the senior hierarchy.
Yes, sir. 36, superior officer. And at the same time, since magistrates have supervisory powers, my lords, promptly reporting to the magistrate, also seeking a permission from the magistrate and proceeding further. That is on the next page, page 172, para 20. Let's para 20 to resolve this situation.
Yes.
Following guidelines are laid down in case of simultaneous filing of 156(3) application and section 200 complaint. As regard 156 CRPC application, the procedure as per para 5.4 bar A, which we have seen, be followed. The police form 156(3) CRPC application alleging improper or delayed investigation, simpliciter or along with non-registration of FIR should not be granted more than 60-90 days or any longer period of time statutorily prescribed, that is special enactments, 180 days it would go up to. If the police submits a report within 60-90 days or any longer period of time statutorily prescribed, then the magistrate may pass appropriate direction in accordance with law to either dismiss or dispose of 156(3) application with or without directions by passing a speaking order or to supervise and monitor the investigation process if need arises. However, in case the police fails to submit report within 60 to 90 days or any longer period of time statutorily permitted, then the magistrate shall proceed with the complaint under 200 in accordance with chapter 15 and 16 of the CRPC, notwithstanding the bar in section 210 CRPC. While so proceeding under chapter 15 and 16, the magistrate shall keep in mind that as and when police report under section 173 CRPC is filed and cognizance of offence in police report is taken, then the magistrate shall club the complaint case with the charge sheet filed by the police and proceed to adjudicate both the cases together, treating them to have arisen from police report. This is one place, I thought Madhya Pradesh has taken this very proactive step. What was overall not achieved through various pronouncements of Supreme Court where matters are still pending. Despite that, this proactive step in trying to put a time frame, that could be the need of the hour given here. That's the reason I said this is the most important judgment of 2021.
You just repeat this last point, what you are saying.
Please.
No, what is the implication of that?
Of
Roman 4, is it?
Roman
5.
5. Well, it's simple, because 210 says when a complaint is filed and you know there's an investigation going on. Now, as I pointed out, it can be two circumstances: a separate FIR which is registered and a private complaint filed in one circumstance, or in a private complaint, a reference under 156(3), which has led to the filing of a FIR. These are two circumstances. Now, this private complaint will be kept on hold till this whole investigation process is done. Once the investigation process is done and a charge sheet is filed, then the complaint, my lord, virtually gets merged to this charge sheet and they proceed as though it is based on a police report. So state will be the prosecuting agency and not the private counsel who is representing the complaint. That will be the outcome of it.
But that's what would happen in case it was even private complaint 156(3) is referred and report is given.
So 173, then the private complaint virtually merges, state takes over the prosecution. And if at all I want to assist through the new procedure 3012, I may have to seek permission to assist the prosecutor. But if I also want to be heard, 24(8) provides. I say
in effect, now when his grievance of the police not having taken action of the private complainant is taken care of by their filing the report. So the court says that this private complaint would merge with that report.
Yes, that's what happens. 210. That's the intention behind that. Section 210. 210 and 8, subsection 2. In subsection 2 there, because if a report is made by the investigating officer under 173 and on such report cognizance of any offence is taken by the magistrate against any person who is an accused in the complaint case, the magistrate shall inquire into or try together the complaint case and the case arising out of the police report as if both the cases were instituted on a police report. That will be the question. One other aspect was on 156(3). One judgment was of notice page 406 minutes. Sakiri Vasu was the state of UP, 2008, SEC 409. That is where the Supreme Court recognizes his power of supervision under 156(3). Also, notice at page 412 minutes.
Paragraph
26 onwards, page 412. It recognizes his power of supervision, Supreme Court. 26. If a person has a grievance and his FIR has not been registered by the police station, his first remedy is so and so. Approach superintendent of police under section 154(3) or other police officer referred to in section 36 CRPC. If despite approaching the superintendent of police or the officer referred to in section 36, his grievance still persists, then he can approach the magistrate under 156(3) instead of rushing to the High Court by way of a writ petition or petition under 482. Moreover, he has a further remedy of filing a criminal complaint under 200. Why then should writ petitions or 482 petitions be entertained when there are so many alternative remedies? As we have already observed, that's about 482 and 36 and 154. I'm sorry, my lords, one paragraph that I missed pointing out is this para 11, my lords. Para 11. My lords will notice, in this connection, we would like to state that if a person has a grievance and the police station is not registering his FIR, then he can approach SP under section 154(3) by an application in writing. Even if that does not yield any satisfactory result in the sense that either the FIR is still not registered, next portion, my lords, or that even after registering it, no proper investigation is held, it is open to the aggrieved person to file an application under 156(3) CRPC before the learned magistrate concerned. If such an application under 156(3) is filed before the magistrate can direct a FIR to be registered and can also direct a proper investigation to be made in a case where, according to the aggrieved person, no proper investigation was made.
Now, this could be extended to even cases where if it's postponed indefinitely, filing of charge sheet, we can simply, in the pending case itself, go under 156(3) and seek appropriate direction for them to file. So the petitioner in this case, instead of filing mandamus, could have filed under.
Could have done that. Because in each matter, it has to be viewed.
No, it has to. We have to. There must be some clarity on.
This matter, I have opposed the district.
I'll come.
I'll come.
I'll come to. I'll come.
No, my lords, was pleased to. This is insofar as, my lords, how the guidelines could be laid. Now, my lords asked me modalities of how we could do this guidelines.
So, how are you placed post lunch? You have some matter. Yes. Yes.
Only thing I will point out, about 4 judgments of High Court where guidelines have been laid. 2 of His Lordship Justice Panindra, my lords, 1 of Justice Navrata, and 1 Suraj Goel has also laid down guidelines, and Justice Harish Kumar has also laid down guidelines. I will give those judgments, my lords. It becomes easy to see the modality of doing it.
So, what I was thinking now, now, no doubt, there are petition under 482 is pending. That apart, only on this larger issue, while noticing the relief that he has sought for, without necessarily indicting or getting into the facts, only with the context in which the petition came to be filed, merely stating that, then in that context, we can say that this is a repeated occurrence in other matters where such pleas are put forth. And in the context of mandamus having been filed, we could put this 156(3), etc.
Mandamus and also, my lords, exercising powers, inherent powers. Inherent powers is always inherent in the code, 482. It is not a power conferred by the code also. It is something as a superior court, the court has.
And the guideline is being made in light of what we observe as a recurrent fiasco in all other matters also. In that context. So the only thing is, I would not like it to make as a general. So what in the context of this, we can lay it down as a guideline.
Also, my lords, a remedy to a malice. That's all, malady or malice, remedy to that. Because we are repeatedly seeing it in all the cases. So somewhere when it's streamlining it, may be required. What extent we may succeed later is different, my lords, but at least an attempt towards that
Yes.
would help.
So tomorrow we'll continue.
15 minutes, I think.
This is a matter for further hearing tomorrow. Yes. Yes, yes.
I have some say because the delay was the complaint is whether these can be adopted in this petition also has to be managed. That's one of the reasons I need some time.
Let us see. We just discuss what is his apprehension in advance so that you may address it.
Court officer? Court officer?
ಸರ್ ಹೇಳಿ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಸರ್
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ ಸರ್ 24 ಅಲ್ಲ ಸರ್
ಹಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಪಾಸ್ ಅವರ್ ಆಗಿದೆ ಸರ್.
ಮಧ್ಯಾಹ್ನ ತಗೋತಾರ ಸರ್?
ತಗೋಬೋದು ಸರ್ ಮಧ್ಯಾಹ್ನ. ಪಾಸ್ ಅವರ್ ಮಾಡ್ರೆ ಮಧ್ಯಾಹ್ನ ತಗೋಬೋದು.
ಎಷ್ಟಿದೆ ಸರ್ ಪಾಸ್ ಅವರು?
4 ಇದೆ ಸರ್.
4 ಇದೆಯಾ? ಸರಿ ಸರ್.
Further hearing. Further hearing matters. List number 4, serial number 4, Pradeep Nayak, KV Arvind.
Wait, please. Mr. Gulati is just joining. Give us just 2 minutes.
Yes, yes. Come back, sir.
May it please, my lords.
Yes.
Lord, before starting, my lord, I had yesterday made a point to your lordships that a large part of my learned friend Mr. Arvind's arguments are beyond the order impugned and also beyond the pleadings filed before your lordship. And I want to point out at least 7, 8 of those arguments, my lord, point by point, before getting into, my lord, rebutting those arguments. First, my lord, is on the issue of maintainability of the application under section 195(2). Second, my lord, on the sufficiency of data available before the authority in terms of whether it's a reimbursement or whether the scope of services is known or not known. No objection has been taken, my lord, as far as the authority is concerned, and I'll show to your lordships, my lord, that this has gone through several rounds of discussions before the authority, and neither is that a case in the statement of objections for your lordship. Third, my lord, the fact that these are reimbursements, we have stated it explicitly before the authority, time and again. It's not disputed. No dispute at all. Even in the statement of objections, they take it that even if it is such, it is irrelevant. That's the basis, but it's not disputed. Fourth, this whole interpretation of Article 12 to say that the make available clause does not apply to services provided through personnel. First of all, that argument is wrong. And secondly, it's not the basis. It's never been the basis. Fifth, that whether or not in a particular case a service P is alleged, like it was alleged in Centrica, it has any relevance or not. They say that now in oral arguments, they are saying it's irrelevant. Never been the case. Binding judgments of this court have been ignored, not just of this court, also of the tribunal. As far as the assessing authority is concerned, it's also bound by the tribunal judgments. Have been ignored, not because they are not good law, they've just been ignored. Before your lordships, of course, again in oral arguments, it has been said that those judgments have no ratio because questions were not admitted. I'll deal with that separately, but that's not been the case of any authority. These judgments are cited before them. They are simply ignored. They prefer to follow Centrica, which according to me is not applicable. And in my respectful submission, in any case, some parts of those findings are directly contrary to the treaty. I'll show that. And anyway, my lord, Centrica is not binding on your lordships. But if there are jurisdictional court judgments which have a ratio, then that ratio, my lord, I would respectfully urge ought to be followed, is my respectful submission. But nonetheless, this was not a point taken. That's the only point I'm taking I'm making right now. Then, my lord, the manner in which Abbey business, a judgment of this court, and Marks and Spencer has been distinguished on facts. Assessing authority is not distinguished, and there is no such distinguishing feature. I'll point those out, not just from the judgments of the high courts, but I've also placed on record the tribunal judgments to show that there is a complete parity of facts. In the next, Lord, again, off the cuff argument made to say that these are related party transactions and therefore parties can choose whatever they want. The fact of dealing with a related party is not an issue raised in the impugned order. And as far as Walmart is concerned, my lord, they are not a 100% holding company of Flipkart Singapore. They are a majority shareholder, so there is no identity, complete identity between Walmart and Flipkart that anybody can sacrifice their income if the income is due to them, and it won't make a difference. Again, something which is totally bereft of pleadings. Now, my lord, with that background, may I first invite your lordship's attention. My lord, as I was mentioning to your lordships yesterday, first of all, my lord, a lot has been said to establish that this will not apply, that will not apply, but let's, my lord, go on the broad concept of what we are dealing with here. My lord, the broad concept of what we are dealing with here is that is there a contract between Walmart and us, the petitioner, by which Walmart is providing services for a consideration? Walmart is providing the services. And that is the crucial determining factor. That's point one to be determined. Whether Walmart is actually providing these services for a consideration. If the answer to that is in the affirmative, only then can any other question arise. And what will be those questions? There are two questions if the answer to the first one is in the affirmative. And that first question is not dependent on what I ask the secondee to do. That first question is dependent on the nature of the contract between Walmart and me where this activity. If the answer to this first question is in the affirmative, the second question needs to be determined is, that are the services provided by Walmart of the nature which can be considered as fee for included services? Or are they technical or consulting services which are covered under Article 12? Second question. And I emphasize again that this second question arises only if Walmart is providing me the services, not the employees. And the third question will be that even if these technical services, if they are in some sense technical or consulting services, under this particular treaty, are they made available according to the make available clause? Three distinct questions. None of which, in my respectful submission, can apply to this case. And made available, as far as made available is concerned, the law is extremely clear that even if services were found to be technical and consulting in nature, even then it won't come under clause 12, under Article 12 of the treaty, unless they are of a nature that it's been given to you for you to be able to use those kind of services or technology transfer, etc., at a later point in time. And the basic idea is there a contract which provides for giving of any such services which can be used at a later point in time? Is there anything discernible in the contract on this? So these are the basic questions to be decided, and not whether. And let me now show to your lordships how, my lord, before I turn to the impugned order, just kindly have a minute the treaty once, because I was at the treaty yesterday, my lord, briefly in the evening.
No, so according to you, it is the master services agreement alone that would be the subject matter of scrutiny.
And my lord, I will establish from why I'm saying this is also important, that if Walmart has not agreed to render me services under this portion of the contract, then my lord, what I ask my employee to do, if I have asked him to do 4 things, or if I ask him to do an additional 5 things, that does not result in an income to Walmart. And what we have to determine is whether the payment being made to Walmart is in the nature of income which can qualify as sum chargeable to tax. So the 4th thing or the 5th thing that I ask the employee to do, for which Walmart is not answerable, does that lead to an income in the hands of the Walmart, is what we have to determine. And my lord, your lordships will also note one thing, that insofar as the master services agreement is concerned, that is not in challenge. Nobody is saying that it is an incorrect or a sham agreement. That agreement in terms says that for this part of the activity, it is only the actual cost of wages and sums incurred will be paid to Walmart. Nobody has found that agreement to be incorrect. It may be a related party agreement, but there's nobody's case. In fact, they are relying on this agreement to come to the findings. So they can't approbate and reprobate at the same time. They can't accept a document and not accept the document at the same time. So once this agreement, my lord, is not in dispute, and the agreement in terms says that all I'm responsible for is to send this employee to you, which you have identified. All I'm warranting you is that he's the employee, and he says he's qualified in a particular manner, and I'm sending it to you, and I will only charge you the wages. This is the agreement. Now, whether I ask him to do 4 things or 5 things, will that lead to an income in the hands of the hands of Walmart is what needs to be seen. And in my respectful submission, the scope that I identify for the employee, because he's been treated as my employee, will not change the character of this payment in the hands of Walmart. It will not become income.
just because I asked the employee to do one extra thing or one lesser thing. And I'll make that good, my lord. I'll make that good. I'll point it out both from the treaty as well as from our agreement, how this is an incomprehensible, my lord, argument which is being made to fit it under this. It goes against the very tenor of, my lord, what this is. Kindly have page 38 of my paper, of my compilation for a minute, my lord. My lord, page 38, again, my lord, I'm inviting your lordship's attention to 12.4, my lord. For the purposes of this article, fee for included services means, so it's a means, my lord, definition, your lordship will note. It's not so it's a very specific definition. It's not, my lord, and it's an exhaustive definition. It's a means definition. Means payments of any kind to any person in consideration. So, my lord, your lordship will mark that the consideration, the payment, first of all, which is being made, has to be a consideration in the hands of Walmart. For what? For rendering of any technical or consultancy services. Therefore, necessarily, the first finding has to be that Walmart is rendering, not the employees, but Walmart is rendering me services for a consideration. Now kindly see the bracketed portion. Including, and this is only clarificatory of the main part. This does not say anything else. Including through the provision of services of technical or other personnel. My lord, the point I'm making here is that this inclusive part is again where Walmart is rendering me services. This is not talking about a supply of personnel. My lord, a company renders its services through personnel. So if I have a consulting program, my lord, to take an example, that I have engaged McKinsey in the US for a consultation, my lord. McKinsey sends its employees not as secondment, but through his employees, it's rendering me services at site in Bangalore. That is also included in technical services, is all this is saying. This is not talking about secondment. This is talking about the main entity which is providing technical services, including through personnel. It could, my lord, a service, a software service, they could, my lord, build a software for me and send me, where the interaction of any employee of that organization may not be necessary. Else it could send people to my place and could render service. It could be both. So the inclusive portion only amplifies on what is included in the means part. And both of these, there is no, my lord, indication at all that this make available clause will not be applicable to the entirety of this, the parenthesis in clause 4. Otherwise, my lord, they could have separated it. They could have said any technical or consultancy services made available so and so. This applies to the entire clause. And this is clear from the explanatory note also. There is no such caveat anywhere. First of all, my lord, the inclusive part is not talking about a secondment. It is talking about only the organization, which is the contracting organization, when it is providing the services, including through its personnel. And the A and B, B therefore relates to what exactly are those services. Those services are which are made available, which make available technical knowledge, experience, skill, know-how, or processes, or consist of development and transfer of a technical plan or technical design. Therefore, not everything, not a legal service, which is, my lord, a legal person is providing, who's been seconded here, or a finance person is providing. It should be of a nature which is, and therefore, my lord, the leap of faith, both in oral arguments as well as in the impugned order, which is saying that merely because a person is qualified, therefore it becomes technical, is absolutely wrong, in my respectful submission. Just because somebody is qualified does not make it a technical or consultancy service. Technical or consultancy is, it has to be of a nature where technical knowledge, experience, skill, know-how, processes, or the development and transfer of a technical plan or design. This is the nature. And now, my lord,
just one point.
Yes, my
Now,
lord.
the argument of Arvind appears to be that even if you were to accept the make available clause, make available technical knowledge, experience, skill, know-how, or process, and consist of development and transfer of a technical plan or technical design appears to be his argument. So he was canvassing the point that there must be development and transfer of technical plan or technical design. So the last part, or consist of how do you read the last part vis-a-vis the earlier part?
My lord, I think the make available, if, my lord, the make available would not have been there in the beginning, it should have been there only in the last after and make available. Had it been like that, it would have been a different issue. It's not like that. And my lord, it's made clear, my lord, there is an explanatory memorandum to this treaty, which is part of the treaty, which starts at page, my lord, the relevant part for us is at page 49. Kindly see how the treaty itself explains this. Page 49. And this is talking about the entire Article 4B. Para 4B of Article 12. My lord, does your lordship have in the middle of the page para 4B?
Yes.
Para 4B of Article 12 refers to technical or consultancy services that make available to the person acquiring the services technical knowledge, experience, skill, know-how, or processes, or consist of the development and transfer of a technical plan or technical design to such person. Now, my lord, they are not making any distinction that it applies only to one and not to the other. For this purpose, the person acquiring the service shall be deemed to include an agent, nominee, or transferee of such person. This category, the entire category, my lord, is narrower than the category described in para 4A because it excludes any service that does not make technology available to the person acquiring the service. Generally speaking, technology will be considered made available when the person acquiring the service is enabled to apply the technology. The fact that the provision of the service may require technical input by the person providing the service does not per se mean technical knowledge, skills, etc. are made available to the person purchasing the service within the meaning of para 4B. My lord, it can't be more explicit than this. And this is exactly what this honorable court has said in Abbey. Similarly, the use of a product which embodies the technology shall not per se be considered to make the technology available. So even that is not enough. Even if the technology is embodied in a product, it is not enough. And my lord, kindly see there they go on to explain by way of examples. And example after example will establish that the service of a technical nature is being provided by that organization, not just by a person who becomes my employee. My lord, now kindly see how they explain this. Typical categories of service that generally involve either the development and transfer of technical plans or technical designs or making technology available as described in 4B include engineering services, including subcategories of bioengineering and aeronautical, agricultural, ceramics, chemical services, electrical, mechanical, metallurgical, and industrial engineering, architectural services, and computer software development. These are the kind of services of enduring nature which are provided, my lord. Only then can it come. Then, my lord, under 4B, technical and consulting services would make technology available in a variety of settings, activities, and industries. Such services may, for example, relate to the following areas: biotechnical, food processing, environmental and communication through satellite or otherwise, energy conservation, exploration of mineral oil or mineral gas, geological service, scientific services, and technical training. The following examples indicate the scope of the conditions of 4B. My lord, compare this with our contract, which is talking only of sending employees identified. My lord, even by a long shot in my respectful submission, it can never fall under this.
Part of the treaty at page 46, it is said that it is.
And this is, my lord, explicitly made part of the treaty at page 46. Top, if your lordship sees, at the signing today of the convention between the United States of America and Republic of India for the avoidance of double taxation, prevention of fiscal evasion, respect taxes, so undersigned have agreed upon the following provisions which shall form an integral part of this convention. And this goes on. So this is, my lord, agreed between the parties. This is how we'll construe it. Now, my lord, kindly see some of these examples.
To understand, you
Yes.
are saying that these illustrations or explanations are a part of, are to be construed to be a part of the treaty, and it's not an external aid as such.
No, not at all. Not at all. Parties have agreed that this is how we understand the terms of this agreement. Both India and America have signed off on this, and they have agreed that this is, and this is how, my lord, courts have interpreted it also. The court interpretation of what is make available is consistent with this explanation. It's not any different. My learned friend's attempt is quite different, to say that just because somebody is a CFO or a legal and he is qualified, therefore it will amount to technical service or of a consulting nature. And that also being provided by Walmart. My lord, that in my respectful submission doesn't follow from this at all. And kindly see some of these examples. I'll make this good, my lord. I think, my lord, it's very, very clear that this is clearly beyond the ambit of what this entails. My lord, these are internationally accepted practices. These are not something that somebody, my lord, can just construe it such that anything can come fit in here. These are very, my lord, well-established terms. And there is a lot of jurisprudence on this. In fact, my lord, I stopped short at not showing your lordship's tribunal judgments. Those are, my lord, tribunals have considered this time and again and have come to a very clear finding and upheld by courts. So, my lord, there's been a very consistent line to say what will constitute this kind of a thing. Kindly have example number 3 first. And in some of these examples, clearly the service was identified to be technical. In our case, it's not even that. Even then, they said because it is not made available, it won't come under this. I'll show that, my lord. My lord, example 3. A US manufacturer has experience in the use of a process for manufacturing.
Page?
My lord, say page 50. I'm so sorry, my lord. I've reverted to page 50. Where your lordship is reading. Example 3.
Yes.
A US manufacturer has experience in the use of a process for manufacturing wallboard for interior walls of houses which is more durable than the standard products of its type. An Indian builder wishes to produce this product for its own use. It rents a plant and contracts with the US company to send experts to India to show engineers in the Indian company how to produce the extra strong wallboard. The US contractors work with technicians in the Indian firm for a few months. Are the payments of the to the US firm considered to be payments for included services? Yes. The payments would be fees for included services. The services are of a technical or consultancy nature. In the example, they have elements of both types of services. The services make available to the Indian company technical knowledge, skill, and processes. Now, my lord, this is the typical example where the US company is contracting to provide this through its employees. So this is coming under the first part where they are coming and doing this on behalf of the US company. They continue to be US company's employees. And the consulting is being provided by that company through their employees who are coming in India and make available as applicable. So it's not just the transfer of the technical design where make or the plan or the design to which make up available applies. It applies even to consulting rendered through employees who come to India. Your lordships will note one thing, my lord. In a consulting contract, these people who come in don't come on an employment visa. They come on a business visa. The condition precedent to our contract for secondment is that they will take an employment visa. They will come and be employees with us. PF is not deducted on consulting contracts, my lord. We deduct PF because these are our employees. These are statutory payments being made. Professional tax, PF, income tax deducted at source, all statutory payments unrebutted, where we treat them as our employees. So there is no question of Walmart taking responsibility for any consulting of any work that these work people do here. Example 4, my lord. A US manufacturer operates wallboard fabrication plant outside India. An Indian builder hires the US company to produce wallboard at the plant for a fee. The Indian company provides the raw materials and the US manufacturer fabricates the wallboard in its plant using advanced technology. Are the fees in this example payments for included services? The fees would not be included services. Although the US company is clearly performing a technical service, kindly note this. Although the US company is clearly performing a technical service, no technical knowledge, skill, etc. are made available to the Indian company, nor is there any development and transfer of a technical plant or design. The US company is merely performing a contract manufacturing service. Again, whether it is the first part, which is service, this artificial distinction of first part and second part, or it is the transfer of a design or anything not made available. Again, the example says so. So service being technical, despite that not made available, make available not applicable, it will not be fee for included services. Example 5. An Indian firm owns inventory control software for use in its chain of retail outlets throughout India. It expands its sales operation by employing a team of traveling salesmen to travel around the countryside selling the company's wares. The company wants to modify its software to permit salesmen to access the company's central computers for information on what products are available in inventory and they can be delivered. The Indian firm hires a US computer programming firm to modify its software for this purpose. Are the fees which the Indian pays treated as fee for included services? Again, my lord, the contract is with a US company for consulting for modification of a software. The fees are for included services. The US company clearly performs the technical service for the Indian company and it transfers to the Indian company the technical plan. That is the computer program which it has developed. So this is what is in it. Then, my lord, example 6, which again talks about a contract for services by that firm and an enduring benefit. An Indian vegetable oil company, manufacturing company, wants to produce a cholesterol-free oil from a plant which produces oil normally containing cholesterol. An American company which has developed process for refining the cholesterol out of the oil the Indian company contracts with the US company to modify the formulas which it uses so as to eliminate the cholesterol and to train the employees of the Indian company in applying the formulas. Are the fees paid by Indian company for included services? Analysis. The fees are for included services. The services are technical and technical knowledge is made available to the Indian company. It's of an enduring nature. You are giving a technology to the company to produce cholesterol-free oil. Then, my lord, example 7 is extremely important because commercial knowledge of the person or commercial, my lord, interest, knowledge, whether that can, my lord, lead to a inference of fee for included service. Example 7. The Indian vegetable oil manufacturing firm has mastered the science of producing cholesterol-free oil and wishes to market the product worldwide. It hires an American marketing consulting firm to do a computer simulation of the world market for such oil and to advertise it on marketing strategies. Are the fees paid to US company for included services? Now kindly see, we are past that stage of preparing or giving the technology. Now it wants to market and it is engaging the US firm to help it to market commercial information. The fee would not be for included services. Now let's see the reason, Malad. The American is providing consulting service. So Malad, it is consulting all right, which involves the use of substantial technical skill and expertise. Now this is very important, Malad. Commercial service, consulting, technical skill and expertise. It is, however, not making available to the Indian company any technical experience, knowledge or skill, etc., nor is it transferring a technical plan or design. What is transferred to the Indian company through the services contract is commercial information. The fact that the technical skills were required by the performer of the service. Now, kindly note this. The fact that the technical skills were required by the performer of the service in order to perform the commercial information service does not make a technical service within the meaning of 4B. So my secondee, who may be a lawyer, and because he's technically qualified to be a lawyer, does not make it a technical service. Or the CFO is a finance professional, or a deputy CFO is a finance professional, and he has knowledge of finance, does not make it a technical services. It cannot be included service. They're not making available any technology of enduring nature to me. So this whole argument.
So if there's an example wherein you engage the services of a foreign entity to do some public relations exercise, or you engage a law firm to give an opinion on a certain problem, those services exhaust themselves in that exercise itself.
Exactly. Exactly. Your lordship is absolutely right. And this is the exact example being given in example number 7. This is exactly, your lordship example is absolutely apt. It fits into example number 7. This analysis, my lord, creates, my lord, a very, very clear indication of what is this. The service is consulting. It is also technical skill is required to render that consulting. But, and the information is commercial in nature. But it's a job. There is nothing which is being given as an, or nothing of an enduring nature which is being transferred. It's a job. I was contracted, I did the job, finished. And that is exactly what, my lord, your lordships have said in Abbey. It's totally consistent. Also in DBS. Make available is explained in DBS. Therefore, my lord, by the very nature of the contract, this can never be considered, my lord. Now, kindly, my lord, turn to the contract for a minute with me, my lord. My lord, that's at page 105. My lord, because your lordships are turning to the contract, may I just repeat 3-4 points, 5 points, prefacing 5 points, my lord, on this contract, which your lordships will kindly note if your lordships don't mind. My lord, this agreement has been relied on in the findings. So they cannot negate this agreement. Point 2, the plain tenor of the agreement has to be accepted by them because there is no finding that I have done anything beyond the agreement.
Now are you also saying that at this stage you can't go beyond what the agreement says, and if at all there is any finding that beyond this, that is at the stage of the
Absolutely.
recipient.
Also, my lord, no presumption can be raised unless there is some kind of proof or evidence to say that you have given anything more than, or you are doing anything more than what the agreement suggests. You can't just, my lord, raise a presumptive argument like this to doubt a valid contract. You are yourself relying on this contract to raise allegations. You can't. There is nothing, my lord, on record to suggest that this agreement has not been, my lord, implemented in its very terms. So these kind of prejudicial, presumptive arguments, my lord, cannot be entertained. And kindly see, my lord, there is nothing to suggest that Walmart is earning anything out of this activity. Nothing at all. And this agreement, my lord, if Walmart was rendering a consulting service to me, my lord, whenever I enter into a contract, today, my lord, even as lawyers, my lord, when we engage law firms, clients engage law firms, my lord, there is an engagement letter which is signed. All, my lord, in fact, in cross-border, no work gets done without engagement letter. In domestic contracts also, my lord, today, even law firms sign engagement letters. Scope of work is delineated because the deliverable the service provider is answerable for. Where, my lord, you are merely seconding, you are not bothered about the scope of work. You have identified this person. I tell you that this is this person, his background check. I'll show, my lord, the warranties that I have given, that Walmart has given in relation to secondees, as against the warranties that they have given for services. Services are not part of what we are dealing with here. They are not bothered about what the employee does. They are only bothered about, this is the person, I've done the background check. He has this requisite qualification which he claims. That's it. I'm not bothered about what you make him do. You are taking it at your own risk. I'll make that good. With this preface, kindly see this agreement for a minute.
So now, does the nature of tie-up in the the background of the tie-up between the foreign entity and the petitioner, does it throw light on this aspect? In the sense, now whether the tie-up is in the context of providing some technical expertise or because it has some pluses on some skill, etc., or is it only a business arrangement?
It's a business arrangement, and my lord, today Walmart has sent their employees here. Tomorrow I may be asked to send employees. It's an agreement which works both ways. It's not as if I am, my lord, this agreement is a general agreement. It's a master services agreement. It's an enabling agreement. Today, my lord, they have sent. Tomorrow I might have to send. Under this, they can also ask for personnel. There's no problem with that. My lord, these are basically cooperation agreements between companies, which, my lord, are, and it happens, my lord, both in the realm of domestic, my lord, commercial transactions as well as this, that if there is a large group, supposing, my lord, there is a Tata group, it has 100 companies. somebody needs an urgent finance professional, they can ask another Tata Group company to say, can you lend me that professional for a year? Or they can recruit it from outside. My lord, it happens all the time. That does not mean, my lord, that this comes under something which is called fee for included services. And my lord, kindly see, my lord, as far as this agreement is concerned, para 1.7, what does secondment mean? Secondment means the relationship assigning a secondee by a party to the other party as contemplated. You just assign. And when you assign, you divest your control over that person, and that person steps into the shoes of the employer. That's all. As against that, 1.8, services means the particular service to be provided by one party. In secondment, you just assign, and once you assign, that person will provide the service directly to you. But in 1.8, the contracting party is providing the service. Big difference. To or for the benefit of the other party pursuant to this agreement and the applicable annexure so and so. Then kindly see 2.1 and 2.2. 2.1. The use of certain services, the first part is services, not secondment. 2.1.1. The parties may from time to time request from the other the following. And that is why, my lord, I said that this is reciprocal. Either party can request. This is not as if Walmart possesses some expertise or some expert employees who are going to give me technical services. It could be either way. The parties may from time to time request from the other the following. First is not relevant, but I am just reading it for contrasting it with 2. The use of certain services as more fully described in Annexure A, or the scope of work included between the parties and their affiliates for the relevant service. And 2, which is relevant for us. So Annexure A, your lordship will note, is in relation to services. Time and again, my lord, I pointed out, but both in the impugned order and in the statement of objections, this has been confused. Annexure A, which is at page 112, is not relevant for secondment. It is only for services. And all this trading, etc., my lord, it can come only under A. It does not come under B. Now, 2.12, the use of certain secondees on the terms and conditions described in B, unless the parties agree to the contrary in respect of particular secondment in this relevant scope of work. And B only refers to the global assignment letter. That is at page 114. So I do not agree, I as Walmart do not agree to any scope of work where I am providing a service to Flipkart when I assign a person. Thereafter, what Flipkart says that you, Mr. A, you will do 1, 2, 3, 4, 5 activities. How is that relevant to Walmart? If I have not, my lord, contracted to provide any services, can I be held liable in law if there is a deficiency in service? That's the test. whether or not I have provided any service at all, let alone it's a fee for included services, or it is a service of a consulting nature or a technical nature. Am I at all liable to the contracting party for any service? That's the test. And that's why I said, my lord, that these arguments to say this is not available, that is not available, they're all irrelevant. The nature of the contract is such that it can never be inferred that this is fee for included service. Now, my lord, there is another confusion which was created in the impugned order as well as, my lord, in oral arguments. Your lordships will come. First of all, my lord, termination. My lord, if your lordship sees 107, para 3.1, the last line. In respect of services of secondees referred to para 2.12 above, Flipkart may terminate the services of secondees for any or no reason. My lord, if it's a consulting contract with Walmart, where Walmart is providing me services and they are entitled to a fee for a deliverable, can I just terminate it for no reason? Then what's the meaning of this consulting contract? Whether or not they have given me any consultancy which is of an enduring nature, today I am 90% through with it and the milestone was at the 100% level, I say I terminate it for no reason. The indication is clear that Walmart has not contracted to provide any service. It's for a term that you've taken on an employee. Whether you want him or don't want him is your lookout. Now, my lord, on compensation, time and again, your lordships were told, my lord, it's there in the impugned order also, and in the statement of objections, they have referred to, my lord, these fully loaded costs, including all actual documented and costs and expenses, so and so, for the scope of work in 4.1. This relates to services, my lord. In relation to secondment, 4.2, kindly see. It is so explicit. What proof do you need beyond this? In consideration of secondments, 4.2, the party placing the secondees shall invoice the party receiving the same on a quarterly basis, the compensation and wage costs of the secondee as incurred by the home country, including all secondment costs, expenses, and incidental costs. That's it. And this is what the invoice is. Expat costs.
Now, one clarification. Why do you say that the revenue cannot go beyond what is stated in the agreement?
Well, not as a general proposition. All I'm saying is that today it is all presumptive. I have claimed, my lord, this is the agreement, and I put the invoice on record to say that these are actual costs being done. There is nothing contrary on the record. Nothing contrary. Lord, revenue can investigate anything. There's no, my lord, bar on the revenue's power of investigation. I can't even, my lord, attempt to argue that proposition to say that the revenue is not entitled to investigate. Of course, they can investigate. But today, my lord, the agreement and the documents establish that what, and my contention is not found to be wrong. I won't place it higher than that.
Are you also saying?
And my lord, one thing you'll also keep in mind that what we are determining here is whether Walmart is rendering me any services and whether they are charging any consideration for those services, which can be regarded as fee for included service. That's the scope of the inquiry, my lord, that we are in. Here, my lord, if Walmart is not undertaken to render me any services, where is the question, my lord, of somebody suggesting that one, there is consideration, and two, that it becomes a service which Walmart is rendering to me. My lord, just read on with me for a little while more, my lord. Just come to the general warranties now. What are the warranties that they give when they provide services, and what are the warranties that they give when it's secondment? It will again, my lord, be clear. The contrast will be clear that when it is a services contract, when it is a service being rendered, whether or not it's technical is another matter. The nature of the contract will be different from what it is in secondment. With respect, my lord, 6.1 at page 108. The first one is in relation to services. With respect to the provision of services, each party warrants as applicable to itself to the other party that it has full and exclusive right and power to enter and perform according to the terms of the agreement and each scope of work. So the party will perform and it is competent to perform. Then 6.1.2, the services will meet the specifications. Why? Because the party is which is the contracting party, which is performing the service described in the applicable scope of work and will be complete and accurate and will comply with the applicable laws and regulations. Work product created by a party's employees will be deemed created within the scope of their employment. So, my lord, what does this 6.13 mean? That if it was Walmart providing the services under one and their employees had worked on it, it is part of their employment to Walmart and the product will belong to Walmart. It may be delivered to me, but product belongs to Walmart and it is in discharge of a consulting or scope of work which they would not do this. Now, kindly see,
parties employees means
that parties, the service providers parties. Because, my lord, as I explained to your lordships, that a consulting organization will use its employees to render consulting. Now, kindly compare this with secondment, 6.2. With respect to secondment, the party sending a secondee, so he's only sending a secondee to the workplace of the other party warrants the following. The
just one. Now 6.1 is it to be only to A?
Services, my lord. My lord, I have pointed out right from the beginning that services and secondments are dealt with in each clause separately. And therefore, my lord, this with respect to provision of services, it says so. And 6.2 is specific to secondment. With respect to a secondment.
No, so this 6.1 is for annexure A.
Is for annexure A. Services are defined in 1.8. Secondment is defined in 1.7.
Yes.
Now kindly compare 6.2. With respect to a secondment, the party sending a secondee to the workplace of the other warrants the following. The secondee is in good standing with the party employing the secondee. So, my lord, he is not a person who has been determined to be not a proper employee. The qualifications submitted by the secondee have been verified and are true and correct after reasonable inquiry or inspection. The secondee is free from any past findings of unethical behavior in the workplace or other sanctionable offense relating to his current employment to the extent that such findings or offense are currently reflected or should be reflected in the secondee's employment history pursuant to the assigning party's employment policies and practices and applicable law. To the best of knowledge and belief of the secondee has the requisite experience, skill or training capable of completing the services contemplated in the secondment. The assigning party warrants that the secondee is work authorized for the jurisdiction in which the work or service will be provided. This, my lord, is in relation to the work visa, which is made clear, my lord, in the global assignment letter as well as in the employment letter. That you will take an employment visa, go and work there. Whereas, my lord, if it was one where Walmart was providing services through its own employees, they don't need a work visa. employment, my lord, stands on a complete, and that is why, my lord, I say, if your lordships recall, that in a separate compilation, I had also shown to your lordships the OECD commentary on secondments, which clearly, my lord, indicate when the person, in terms of secondment, it is the supervision, control and supervision test, and not because somebody is qualified to be a lawyer or a finance professional, that it becomes, my lord, the test. The test is who is directing you to do ABC, not what you are doing. That is not what the test is. Who is directing you? And it, without doubt, my lord, it is Flipkart here who receives these employees. Once they have determined that this is the nature of person, this is the qualification of the person, I will determine what he does with me. That's the test. Now, my lord, kindly see the work, the global assignment letter. Condition precedent, my lord, to this assignment is that you will take a work visa, employment visa in India. My lord, in the third para, this assignment cannot be page 115, my lord.
Now, are you to say that this global assignment is only incidental, and what needs to be looked into is primarily only the master services agreement?
Lord, this is made an annexure. If your lordship sees 114, which was annexure B in relation to secondment, this is made up virtually a part of the MSA. Because all that this is, my lord, dealing with is to say that you are this person, you are going on this designation, you will report to that person. And a condition precedent is you will take a work authorization in the host country.
So you are saying that work authorization would not have been done if he was
not employment. It was if it was not employment with me. If Walmart had been providing services to me, this is not. You won't get a work visa first of all. Then you are working under a commercial contract for your company. You don't need a work visa in India. But we as lawyers have gone outside India for various assignments. We go on a business visa. Even for foreign arbitrations, we go on a business visa, my lord. The person is, my lord, assignment, country, title, position, reports to. He is reporting, my lord, not to Walmart. He reports to somebody in Bangalore. Therefore, where is the control and supervision of this employee? Is it with Walmart? In Centrica, I will show to your lordships, the Delhi High Court, for whatever it is worth, came to a definite finding that the employee was indeed working for the foreign company. They were discharging their responsibilities, the foreign company's responsibilities. In our facts, that finding can never be rendered. Walmart is not concerned with what you are doing here. And therefore, my lord, what compensation he draws, if he was drawing a particular compensation and he has a lien on his employment, is of no avail, in my respectful submission. And at page 120, my lord, when I put my sample appointment letter on record in relation to the finance professional, I tell that person, it is not, page 120 is now my letter. I think it was not made clear to your lordships, my lord, that this 120, which is putting, my lord, the obligations on the employee, it's not Walmart's letter. It's my letter.
What is the CECO?
My lord, where
Page 115.
yes, my lord. Lord, this is, I think, a chief executive. I mean, I'll find out, but I think it's a designation, my lord. It is reporting to the General Counsel and Chief Administrative Officer, Asia Daniel so-and-so, Vice President, CECO, Bangalore, India. CECO. He reports to this person. Well, I'll come back to your lordship on the full form of that. But kindly come to 120 for a minute. This letter confirms the terms and conditions of your employment with Flipkart. Again, contingent upon the approval of your work authorization. My lord, nobody can take an employment in India if he's a foreign national unless he has a work authorization, work visa. Contingent upon the approval of your work authorization, the anticipated start work of your so-and-so is so-and-so for 24 months. Thereafter, it may be extended or a mutual agreement between you and the company, Flipkart India, reserves the right to modify the terms of your employment at its sole discretion. My lord, if it was a contract where Walmart was providing me services, me modifying the terms of the employment of this person was not possible at my discretion without the involvement of Walmart. If they had undertaken to provide me services. The conditions of your employment in India are as follows. I specify each and everything. Who's your employer? Host country, this company. Where is the registered address? Where is your work location? I am determining everything. I can ask him to work at Bangalore. I can ask him to go to Delhi office or whatever. What is your position? Senior Vice President, CFO. Start date. As Senior Vice President, CFO at 121, my lord, you will be responsible for A, B, C, D, E. Walmart has nothing to do with this. And these are day-to-day activities that these persons will render during the term of their employment. Leading and contributing to the business unit's overall strategy and operating plans from a broad business perspective with a focus on the financial elements of the business, providing insights. My lord, this is what a deputy CFO will do. There is no technical or consulting service of an enduring nature that they are going to provide to me. Creating an environment, and it's irrelevant according to me, my lord. My lord, that designation is Chief Ethics and Compliance Officer, CECO. And he has to build a team here from amongst my employees. He's reporting to somebody here. He's working with Indian employees. All of this, I have to deduct PF, etc. All of these facts, my lord, which have a statutory flavor, PF, visa, they are all under Indian statutes. The income tax of today, my lord, in fact, the impugned order does not question all of this. My lord, in oral arguments before your lordships now, everything is being negated to say that all of this is of no avail at all.
You are saying that Arvind is arguing like a petitioner.
My lord, all I'm saying is that there has to be some edifice, my lord, on the basis of which an argument is put up. These are statutory, my lord, all these incidents have a statutory flavors. They have, my lord, I'm filing PF returns, I'm deducting PF, I'm doing TDS compliances, I'm taking an employment, he's taking an employment visa. All of these things are, my lord, establishing one thing very clearly, that they are my employees and I am responsible. The only factor, my lord, that has changed is that Walmart paid them in the first instance for convenience and I reimbursed. Had I paid it, my lord, directly, could there have been a question that Walmart is rendering me a service? Answer is no. And just because, my lord, this was done for convenience, you can't change the nature of the contract. So the answer depends on first examining the nature of the contract. And the nature of the contract is such that Walmart is not providing me services. It is assigning an employee who works for me.
The other thing that comes out is Arvind is not very satisfied with the manner in which the matter was disposed of by the authority. He feels that.
I'm presently coming to the order, and I'll point out finding by finding. My lord, finding may be, those are findings rendered by the authority. That is why, my lord, Mohinder Singh Gill says that now once you come up, once the order is challenged, then by way of affidavits or by way of oral arguments, you can't now start supplementing the order. The order is what it is. And I'll point out, my lord, that those findings are directly contrary to the reading of the DTA and to the well-established law. Directly contrary. And the basis on which, my lord, they have held against me cannot survive. Finding after finding, I'll, my lord, point out, my next attempt is to show to your lordship the order once again. And your lordships will just mark one thing, my lord. Not everything, my lord, needs to be recorded in an order. My lord, this whole scrutiny has gone on for more than a year. And, my lord, where is that? My lord, your lordship, give me a minute. Your lordships will note just a few dates. My lord, I made the application on 15/1/2020, which is at page 142 of the writ petition. This was followed, my lord, by submissions on 12/2/2020, which is at page 175 of the writ petition. Thereafter, my lord, detailed submissions are made before respondent number 1, Deputy Commissioner, on 17/3/2020, page 177 of the writ petitions. Then there are discussions which happen, and email submissions are made on 19/3/2020 at page 183 of the submissions of the writ petition.
Email submission dated
19/3/2020, page 183. There are further emails on 6/4/2020 to Deputy Commissioner R1 at page 184. And the matter is discussed with the Joint Commissioner, and then it goes up to the CIT. On 14/4/2020, submissions are made before the CIT, which is respondent number 4. That is at page 191 of the writ petition. All of these are followed up by further queries which are responded to on 27/4/2020, which is at page 192 of the writ petition. Insofar as the authorities are concerned, right up to the highest authority, which is the CIT, questions asked, answered, they don't find insufficiency of any material to decide this matter. And they are the ones who have my 192 returns. Even in the counter affidavit sworn in by the respondents, they don't make a grievance to say information is insufficient. Therefore, my lord, in my respectful submission, Mr. Arvind may feel, my lord, that more information ought to have been provided, but that's not the respondent's stand.
Are you saying that when in a proceeding of judicial review, the revenue cannot go beyond its order?
My lord, that is why I am saying, yes, my lord, I am saying that. That is why, my lord, I cited Mohinder Singh Gill to say that an order cannot be supplemented. An order contains certain reasons and it cannot be supplemented by affidavits or by other arguments. That's exactly what Mohinder Singh Gill says.
Are you also saying that the department cannot but defend the order?
Yes, my lord. Because ultimately, my lord, what is the reasons, my lord? The matter is debated before the department. I filed an application. They asked me queries. I have responded to them. Today, my lord, fresh arguments before the court, which is not the department's stand, ought not be allowed, my lord, in my respectful submission. And kindly see the order for a minute. My lord, the order is detailed. Your lordships have to test the reasoning, whether that reasoning can stand scrutiny at all. They can't be allowed to make out a new case now, my lord. That is why, my lord, I said that firstly, the matter depends on determining the nature of the contract, whether Walmart is rendering any service to me at all. That's the primary thing to be determined. If the matter doesn't go beyond that, then everything else becomes irrelevant. Now, my lord, kindly turn to the impugned order for a minute. Now, it starts at page 80. And the first issue, my lord, decided is on employer-employee relationship. And your lordship will test this reasoning, whether this is the correct reasoning on employer-employee relationship. Now, my lord, perusal of the MSA shows, my lord, I am at page 85, bottom of the page. Perusal of the MSA shows that WMI shall decide on continuance of their services with WMI in US after termination of their secondment in India. This clause alone proves that the relation between seconded employees and WMI has not ceased to exist. Further, as per clause 4.2, WMI raises after incurring the secondment cost, expenses and incidental costs, the relevant clauses is reproduced so and so. Lord, can this be a test, I ask myself, for determining whether I have an employer-employee relationship with the employee during the term that they are with me? What they do, my lord, after they leave from here, how can that determine, my lord, whether I have the employer-employee relationship with them or not? This is not the test, in my respectful submission. This reasoning is wrong. And the fact that Walmart raises the invoice after, that is the reason why a reimbursement will occur. Whether raise it before or after, that is not the test for employer-employee relationship. This reasoning is absolutely fallacious. Therefore, my lord, And what they are paid, my lord, is irrelevant to determine this. Then, my lord, they straight away go to Centrica, and I'm going to deal with Centrica and Marks and Spencer and all of this, my lord, separately. Therefore, I'm not troubling your lordships about this right now.
Page 87, you said this already deals with whether it is assignment or not inside Centrica 87, second last paragraph. Thus, the employee's conclusion on the basis of agreements.
Now, my lord, kindly see one more line at page 87. Second last para at page 87. Thus, the employer-employee relationship of secondee employees with WMI, with the applicant, it is only a temporary assignment. Lord, the question to be determined was that what is the nature of this relationship with me while he's with me? It is temporary, all right. But while he's with me, if he is acting as my employee and I am the person who's directing him, controlling him, supervising him, that is the question to be answered. Whether he will revert to Walmart or not, all that is, my lord, irrelevant. Otherwise, my lord, it wouldn't have been a secondment in the first place, as I have said, my lord, earlier. So, asking the wrong questions, he's basing his conclusions on the wrong premise. And if this falls, my lord, and if I am able to establish that he has an employer-employee relationship with me and he's working for me, then nothing survives, my lord. Nothing else survives. Then, my lord, he goes into the issue that you have deducted tax under 192 and you've done it wrongly. At 91, my lord, nature of the services rendered by the secondary employees, whether or not FTS, his basis, my lord, at page 91 is, in para 23, from the sample letter of agreement, it is seen that, my lord, this is in the middle of the para at page 23, that the secondees are offered senior positions in management like deputy CEO based in Bangalore, India, as a Walmart Inc. assignee. The reasons for secondment given by a company are, this is the reasons quoted from my lord reply, has entered into inter-company master services agreement in terms of the said MSA. Either of the parties can use certain seconded employees under the terms of the MSA is required to enter into global offer letter with so and so. Now, my lord, the fact that they are senior management positions by itself, how does it lead to determining whether it is FTS or FIS? This is the basis of his conclusion. And in para 25, which Mr. Arvind has also argued at length, thus WMI has assigned certain specific employees because of their expertise and management consultancy skills, which so and so requires for its business development, improvement, or growth. Now, my lord, every employee has skills. That does not make it FTS. That does not make it a service provided by Walmart to me. The entire basis of this, my lord, the structure of the agreement has been distorted, my lord, by alluding to irrelevant considerations.
There's one point. Now, are you saying that despite the wrong questions being asked and answered leading to a wrong conclusion, which Arvind also appears to indicate that not in so many words, still no ground is made out for remand because the legal position itself
is very clear. I'll establish it. I'll establish it, my lord, that the legal position is so clear. These senior management personnel have been seconded umpteen number of times and tested. This does not come under FIS. umpteen number of times. I'll show my lord parity of facts. It's been tested. And this authority had no question. My lord, they had no business ignoring those decisions. My lord, it has to be a receipt of an income nature in the hands of Walmart. And that can happen only if Walmart is rendering the services. Unless they agree to render some services, which the scope of which is specified, where is the question of this being regarded as income in their hands? Undoubtedly, this is income in the hands of the employees for which they are paying tax in India. Again, my lord, if your lordship sees now the consideration of what is FIS in the impugned order at page 94. My lord, if your lordship sees para 36, the payments made to WMI will fall under the second category. My lord, this is how my learned friend has also tried to argue two categories. Second category, here the provisions of services to Flipkart India is done through technical or personal or other persons. Again, this begs the question, is Walmart providing me these services? Or is it that they have assigned them? This through word is in Article 12, where the contract was for providing services between Walmart and me, which is not the case. Therefore, to qualify as FIS, it is not mandatory. This conclusion, my lord, in my respectful submission, is directly contrary to the plain reading of the DTA. Therefore, to qualify as FIS, it is not mandatory that the services should be rendered by the person who is receiving the consideration. The contractual person has to be the person responsible for the services, my lord, is my respectful submission. Every company, when it's rendering consulting, it will use its employees to render the consulting. But contractually, the company is responsible for those services. So this conclusion is absolutely wrong. Even if the services are rendered through other personnel also, it will qualify as FIS in a situation where the consideration received by a person by assigning technical persons to render services, the consideration received by the seconder WMI for services rendered through so and so. So he assumes it is consideration in the hands of Walmart, which is directly contrary to the contract. There is no consideration, they don't provide me any service. Then he gets into reimbursement. Not his case that I can't compare, I don't have the data. He himself says, first I have to determine the nature of the service. If it is a service, then whether you are doing cost or not is irrelevant. That's the way he proceeds. And therefore, my lord, if I am correct in saying that here no service is being provided by Walmart, then, my lord, the second part is a sequitur.
Can it be that fee for technical services and reimbursement are two different conditions that require to be satisfied? And even if it is not a fee for FIS, still, if it is not cost to cost, it may still be construed to be income in the hands of the non-resident authority and hence chargeable under the provisions of the Act. Can it be seen like that also?
I'll answer it in one way, my lord. Any person, unless he is doing an activity for me which is in the nature of a service, and we are not here talking about goods, so we are only talking about a service, is entitled to make a gain from me only if he renders a service to me. If he is not rendering a service at all he can ask for contractually from me that I have just given this employee to you. I paid him X dollars, please pay this back to me. You are using him. The question, my lord, is intrinsically linked to each other. Because had he been rendering service, whether Mr. Arvind may be right in one sense. If it is service, first of all, then you can have a cost plus basis of ascertaining your consideration or whatever. But here, the primary question is that if there is no service being rendered by that party to me, where is the question of him demanding anything more from me? So this is not, my lord, this is not where I'm ascertaining consideration on a cost basis. There is no consideration because there is no service. Those are two different things. You can ascertain consideration in any way. You can do a lump sum, you can do a cost plus, you can do, my lord, those are different parameters, and the measure will not determine the nature of the contract. That's the legal proposition. The measure does not determine the nature of the contract. Here, the nature of the contract is clear, that it is not a service by Walmart, and all that they are entitled to take from me is what they have paid on my behalf to the employee who I use. I debit that entire cost in my P&L account as a salary cost because I have used these services. As far as Walmart is concerned, it is a zero-sum game for them in their P&L. They have not used the services of that employee for this period. They paid something, they have been reimbursed fully. It's a zero-sum game for them. Then, my lord, your lordships will see the conclusion on make available. My lord, page 100, if your lordship sees. Three things, my lord, your lordships will notice here. Para 48. One, he doesn't say, as my learned friend Mr. Arvind has argued, that the make available clause is not applicable if employees are coming through. He doesn't say that. Two, he goes on the basis that merely because qualified personnel are taken, it is enough. And three, he relies on an incorrect clause in the agreement in relation to training to come to an erroneous conclusion that it is make available. These are the three things only. Kindly see now in that slide, para 48. The nature of services provided by the seconded employees are such that experience, skill, and knowledge made available to the applicant. My lord, in the treaty and in the explanatory notes that I have read, this has been explicitly rejected. These seconded employees are also expected to impart training. This is obvious from Annexure A. Annexure A does not relate to secondment. It relates to services. This is the only basis for make available. So it's not as if, my lord, this order is bereft of reasoning or that they had fetters on them to decide this matter in any way. The basis is absolutely incorrect and it is contrary to treaty. It is contrary to the law laid down. And we cited Abbey. At that time, it was the tribunal decision which has been upheld, ignored. And I'll show, my lord, from Abbey and I'll show from other decisions how, my lord, where senior management personnel have been seconded, how has it been dealt with. This conclusion, my lord, flies in the face of those decisions. Now, my lord, may I start now addressing specifics of what has been argued. The first, my lord, argument of my learned friend was that in a situation where nothing is liable to tax in the hands of the recipient, either I should make an admission that something is liable, only then can I go. In other words, what is being suggested is that at the pain of inviting proceedings under section 201, where I will be treated as an SSC in default and prosecution proceedings, and at the risk of getting this entire expenditure disallowed in my books because I have failed to deduct TDS if it was deductible, I should be remediless. Even if there is a fleeting doubt in my head to say that this may, in fact, I am being compliant, I am being over compliant, I am being over cautious to say that I won't take that call, whether it's liable or not. Let me go to the authority and find out. Why should I take the chance? My learned friend argues that this is not a remedy available to you. My lord, whenever your lordships are deciding an interpretation on a remedy available in law, your lordship will give it a liberal construction is my respectful, which will, my lord, enable a remedy rather than disable it. Linked to that is the proposition that an interpretation which will lead to compliance of the law should be preferred rather than pushing somebody towards a possible non-compliance. Third,
just 1 minute, just one. Now I want to know roughly now in order to just adjust the timings over the time left till next weekend, roughly how much more time so that I can mentally allocate the time
Lord,
slot.
if your lordships are able to give me an hour and a half or so, or hour and a half, or maximum allowed 1 hour, 45 minutes or so, I think I'll be able to conclude.
Yes.
Lord, if we have half an hour today, my lord, I'll take that half an hour for till whatever time is suitable to your lordship. So thereafter, my lord, I'll conclude. I'll try and conclude tomorrow itself, if your lordships can give me some time. I won't take it to the next week, my lord. I won't take that chance.
Alan.
This is sufficient because payment is yet to be made. This has to be made. That has already been made.
Good point.
In that sense,
Temperature control. Okay.
I'll just have a cup of water and then we'll proceed.
Yes, Malord.
So how are you finding the video conference?
Malord, it's excellent. At least in your lordship's court.
Yes.
Malord, because we are able, and what your lordship is doing is extremely useful, Malord, where your lordships are putting the mic closer, we can hear the other side also. And we can see the other side also. Malord, it's as good as being present physically. Malord, it's not the same experience. Malord, I have appeared practically in every high court around the country on VC. The interface is not as good elsewhere, Malord. Not everywhere is it this good.
Supreme Court, the same or different? They're using Zoom, something else.
No, they are using now, Malord. Earlier they were on video. Now they are using WebEx. It's a modified WebEx. The only problem there is, Malord, that people don't get unmuted. That control is with the court master. They don't get unmuted. Sometimes, Malord, they are struggling to, Malord, put their point across.
Zoom is better. You can't simultaneously.
This speaker view option is not there. I think one person, but other person is.
That is right. That is right. Malord, in WebEx, you can move, Malord, the court, Malord, even if the judges are in a division bench and they are sitting separately, you can move all of them on stage. So half of the screen, at least you can see the judges clearly. And the rest of it, Malord, comes in speaker. So that's a good feature in WebEx.
Zoom is concentrated. Because once you take an option of speaker view, that entire screen will have over speech, their image is making the entire screen. Otherwise, if you go to the gallery, any persons who are making any distractions, the disturbance will be very large as well as the persons who are arguing. There is one difference.
Yes.
I had an aggression Lordships will not, vision bench sat in their respective residences, even in Bombay High Court, Goa. But they will sit separately, not to the court. But they have two systems, whatever we make, they will have a look at the citations on one screen randomly. Another screen will not for video conference. It's our High Court where video conferencing was conducted completely from the court.
Yes.
Lord, in my respectful submission, the remedy under 195 is available to me. At the stage of application, my Lord, I don't have to admit anything. If I have a doubt, I can approach. The finding of the authority can be that the entirety of it is not liable. Some part of it is liable. And or the whole of it is liable. These are the three possible findings that the authority can come. At the stage of deciding jurisdiction to apply, I cannot predict what is the finding that the authority will come, and jurisdiction will not be decided on the basis of the final order that the authority has to pass. It is a threshold test. 3, at this stage, my Lord, your Lordships have repeatedly put it to me to say that whether or not the authority should look at the matter afresh. Kindly note what is the stage at which 195 is applicable. You go to the authority before making the payments. It's another matter that in this case today, that period is long past. and you have the actual proof of the pudding. But in a normal case, when your lordship is testing a 195, it is on the basis of the contract, on the basis of the reading of the documents which are available, that you will determine whether there is a sum chargeable to tax or not. Therefore, my lord, these documents are enough to establish, and it's a tentative decision which is being made at this stage. And the only determining factor under 195 is whether the sum chargeable, whether the amount being remitted is a sum chargeable to tax or not. And it is a remedy available. It is the only remedy available to the payer. Kindly note this. A 197 remedy is not available to the payer. A 197 remedy is available to the assessee who is in receipt of, who is to receive the payment. And the considerations under 197 are very different. It is not just sum chargeable to tax that will be determined in 197. First of all, my lord, in our case, there is no SSC. Walmart is not accessible in India otherwise. They are not entitled to come under 197. They are not an SSC under this act. They are a foreign company. If this remedy is to be barred, then there can be no prior determination at all. And my lord, because the ambit of 197 and 195 are quite different, the language is different. Here, the language is restricted to sum chargeable to tax. That's the only determining factor. In 197, even if there was a sum chargeable to tax, you can still get a lower deduction or a nil deduction. The rules, there are rules under 197 which have been considered by courts to say, and my lord, 197, I'll show from the language, applies to an SSE. SSE is a defined term under the Act. Section 2, subsection 7 defines SSE. In the Income Tax Act. Please see section 2, subsection 7, SSE. Then I'll take your lordships to 197, and then I'll take your lordships to a judgment under 197.
Yes. Yes.
My lord, this SSC is a person by whom any tax or other sum of money is payable under this act, and includes every person in whom, in respect of whom any proceeding under this act has been taken for the assessment of his income. goes on like this. Every person who is deemed to be an SSC under any provision, every person who is deemed to be an SSC in default under any provision of the Act. Now, Walmart, if it is not a resident company in India and is not receiving any income, has no business coming to India filing applications, my lord. And if a remedy is available to the payer to determine, at least as a tentative determination, that this is something which is not liable in the hands of a payee, that remedy is not barred. And if Lordships will see just one case, my lord, in my compilation, which was a case under 197, where the court, my lord, considers the parameters on which a 197 application is decided, and that will indicate that there's a difference in a 197. It's more that the considerations might be different. It's not just some chargeable to tax which will determine a lower or a nil deduction. To give an instance, my lord, that today, if I am admittedly paying somebody a payment which is liable to tax, but that person has, say, 1,000 crores of losses, and his income today and in this year, even if I'm paying something to him which is chargeable to tax, but there is no possibility of a tax liability in under 197, you can get a lower or a nil deduction. Happens every other day. 195, that can't happen. 195, you are only concerned with some chargeable to tax. Now, my lord, your lordship will come to page 281 of my compilation. This is a case, my lord, argued by me in the Bombay High Court, where the court considered not just the section, but the rules, my lord, which will show the ambit of 197 and how it is different. This is a case of Tata Teleservices. If your lordship sees 284, it starts at 281. 284. What are, my lord, under 197, there are rules framed under Rule 228 AA. My lord, at 284, if your lordship sees Rule 28AA, which has been extracted, where the assessing officer on an application made by a person under sub-rule 1 of Rule 28 is satisfied that existing and estimated tax liability of a person justifies deduction at a lower rate or no deduction of tax, as the case may, assessing officer shall issue a certificate in accordance with provision of 197(1) for deduction at a lower rate. The existing and estimated liability shall be determined by the assessing officer after taking into consideration the following: tax payable on estimated income of the previous year relevant to the assessment year. This is in relation to the SSC, my lord, not in relation to the particular receipt. Please mark this. We are here in 195 determining the tax on a particular receipt, not the overall net result of that SSC's income. What is the tax liability? 2, tax payable on the assessed or returned income, as the case may be, of the last 3 previous years. So, my lord, even if the receipt is taxable, but he had not paid any tax because of whatever reason, because of losses or because of whatever other reasons, he can still get a nil rate. Existing liabilities under the Income Tax Act and Wealth Tax. So, my lord, if it is liable, if it is not, if he's entitled to a lower rate, but there are existing liabilities, it can still be denied. Advance tax payment for the assessment year relevant to the previous year till the date of making the application under Rule 1. Tax deducted at source for the assessment year relevant to the previous year till the making of the application. So how much tax?
Just 1 minute. Yes.
Tax collected at source. Now, these are the considerations why, my lord, the SSC, when he goes, he says that irrespective of chargeability of a particular amount being paid to me, I have no tax liability. Therefore, you can give me either a lower rate or a nil rate. That is not the scope of 195. 195 is only concerned with the particular receipt which I have to remit outside India to see whether it is a sum chargeable or not. Therefore, the comparison of language between 197 with 195 is not an apt comparison. The ambit is very different. And nobody can, my lord, negate that a determination of a sum chargeable under the Act is not to be made under 195. Whether it leads to the conclusion, final conclusion, that none of it is chargeable. That is the exact jurisdiction. Now, my lord, I'll come back to G, but on the last occasion, my lord, yesterday, I had passed on a judgment of this court in Bovis Land Lease India Private Limited. My lord, court master has it. If your lordship can kindly take that. Here, my lord, in fact, what I'm going to show that courts have never, my lord, considered 195 and 197 to be that different to say that remedy is available here and not available there.
So what you have given is Nirma Industries.
So there is one more. Nirma is for the other proposition to say that a judgment under section 268 is still a judgment.
No,
one more, my lord. There is a Bovis Land Lease India Private Limited 2012-22 taxman.com 264.
It was given yesterday or today?
Yesterday. Today?
Today also.
Today also, my lord, I think is given. Is somebody there in court?
Bovis Land Lease.
Yes, yes, my lord. Yes, that is the one. That is the one.
Yes.
Now, my lord, in this, if your lordship comes to my lord, para 12 onwards, my lord, kindly come to para 12. My lord, kindly come to the page where para 13 and 14 are there. The page numbers are not marked. My lord, after extracting 195(2), one para before para 13, my lord, sentence starting as is clear.
Yes.
The court is analyzing 195(2). As is clear from subsection 2 of 195 of the Act, if the person responsible for paying any amount chargeable under this Act to a non-resident considers the whole of such sum would not become income chargeable in the case of the recipient, he may make an application to the assessing officer to determine the appropriate portion of such sum so chargeable, and upon such determination, tax shall be deducted under subsection 1 only on that proportion of the sum so chargeable, which is so chargeable. However, if the assessing authority is of the view that no tax is chargeable, kindly note this, no tax is chargeable, a certificate to that effect could be issued to the person responsible for making the payment. Very clear, no tax is chargeable. Once a certificate is issued, the liability of the person responsible for paying under the said aforesaid provision ceases, and without any deduction, he may make the payment to the recipient. Insofar as section 197 is concerned, it provides for a similar application being made by the recipient of the income. So here they are saying that 195(2) you could have made that. Similarly, the payee could make it under 197. On such an application being made under section 197(1), assessing officer can give him such certificate as may be appropriate. If such certificate states no tax is deductible until such certificate is cancelled by the assessing officer, the person responsible for paying the income is under no obligation to deduct tax while making the payment. In fact, the language employed is shall, therefore it is mandatory in nature. What is the effect of a certificate is a subject matter of interpretation. The Delhi High Court in so-and-so, dealing with the nature and effect of certificates under 197, has held that the such certificate is interim in nature, and in fact the same could not have been anything else but interim in character, as the scope of 197 is limited. On a conjoint reading of 195 and 197 of the Act, if any opinion is expressed at the time of grant of the certificate, it is tentative or provisional or interim in nature, and the same does not debar the assessing authority from initiating proceedings under 147 of the Act on the ground that there has been a change in opinion. Then, my lord, over the page, the quote in Aditya Birla, a certificate under 195(2) creates immunity to the payer under 201 for non-deduction of tax. That is why, qua me, it becomes final, my lord. It gives me immunity. This is the Bombay High Court, my lord, decision and Aditya Birla being quoted. The order under section 1 in nature and does not have any effect beyond providing immunity under 201, and the immunity steps at the stage and does not preclude the assessing officer to either re-examine the chargeable of income in regular assessment proceedings or to recover the taxes from the payer in his respective capacity. Neither words used in the statute nor by any reasonable interpretation it can be inferred that once the certificate under 195(2) is issued, the assessing officer is precluded from the proceeding against the payer in his representative capacity. Liability of an assessee under 195 is in his capacity as a payer, whereas the liability under 163 is as a representative. We are not concerned with that. Therefore, my lord, the revenue is not prejudiced. It's only me who's getting a safeguard today that I will not be proceeded against. Revenue's rights are protected. Then, my lord, after the quote, next quote, kindly see from the word therefore. This is very important, my lord. Therefore, my lord, after the quote I am reading, therefore it is clear that both the payer and the recipient of the payment can approach the assessing authority under the Act seeking for a certificate providing for exemption from payment of tax. That is, exemption from deducting tax at source. Once such a certificate is issued, there is no obligation on the part of the payer to pay the tax. In view of the fact that the word is shall, if the recipient were to obtain such a certificate and make it available to the payer, then the payer shall not deduct tax. Then kindly come to para 16. In the instant case, it is a consistent stand of both the SSC and LLAH that the consideration paid under the agreement is by way of reimbursement of actual expenses. Therefore, even when a credit entry was made in the accounts of the SSC, was treating it only as a reimbursement of expenses, he was under no obligation to deduct tax from the said amount, as the said amount did not represent income. When LLAH approached the assessing officer and made the aforesaid representation on, in this case, my lord, it was a 197 application. Then para 17. Therefore, the entire proceeding initiated on that basis is unsustainable, illegal, and the tribunal was justified in setting aside the same. In fact, the tribunal, while coming to the said conclusion, has taken note of the fact that the assessing officer, while passing the assessment order, did not find fault with the assessee in not complying with the requirement of section 195 and consequently did not allow the said expenditure. In fact, the assessing authority accepted the case of the SSC that the said consideration represents reimbursement of the actual expenditure and granted the said benefit. That is only to point out that if it were to be a reimbursement, anyway, it cannot be liable to deduction of tax at source. Now, my lord, if your lordship sees.
So you are saying that 197 would apply to the person who's the recipient of the income.
Correct. And many other considerations will be looked at. And here it is a receipt-based determination. There it is the overall income-based determination, overall tax liability-based determination of the person. Therefore, there has to be a difference in the language.
Yes.
Today, my lord, if this income is not liable to tax, whether or not he has other income, I am not concerned with. I am concerned with this income, this receipt, whether it's some chargeable to tax or not. And at this stage of application, nobody can predict what the final judgment will be. Whether it is composite, not composite, whether it is liable, not liable, what portion is liable. That determination cannot be made at the threshold level. And nowhere in GE also it says that you have to make an admission before coming to court, before applying. That can't be the situation.
I think even in either 194J, I think, in that ACC case, the court says we can't put an impossible burden on the SSE.
Absolutely. And my lord, why should I take that chance? That is why I said, my lord, that if it was a composite payment, obviously I can't determine what portion of it will be. I will necessarily have to go. G is a situation that having not gone, are you precluded from taking that stand at a later stage? Answer is you are not precluded, even if you have not gone. But who can say that you can't even approach the department? Why should I take that chance? Why should I not rather be compliant? Because, my lord, it's a very heavy burden that sits on the payer. If they were to come to a conclusion that it is in fact deductible, then I become the SSE in default, means the entire recovery can be made against me, as if I'm the SSE. I have to then, my lord, take the burden of penalty, interest, prosecution, and despite the fact that this is a genuine expenditure which I have incurred for the purpose of my business, the expenditure will be disallowed under Section 48.
So you have to say that by virtue of getting a finding under 195, even if in the hands of the recipient it is decided otherwise,
He will have to pay. He will have to pay. I am absolved because I have taken the step.
And 201 doesn't step into play.
Correct. 201 will not apply in my hands. That's what your lordship's judgment has also said. That won't apply. But that person can still be made liable by the department. Because ultimately this is a vicarious liability on me. I have nothing to do with that income. I am not the owner of that income. It's a compliance responsibility.
Yes.
And therefore, 197 remedy is not available to me. This is the only remedy for me. And that's why the context of G is important. My lord, I reiterate once, 56, G is not a case at all. And where the court is saying that a person who wants to voluntarily approach the department to determine whether the entire sum is not liable cannot approach. It's not that case. On the contrary, it is the department which is arguing that having not, and in a case of fee for technical services, mind my lord, in a case where the allegation is fee for technical services, department is arguing before the Supreme, for the first time they raised this contention before the High Court to say that having not approached under 195(2), you cannot be heard to say that it is not income which is liable to tax in the hands of the payee. That context is available at page 58 in para 4. It does not lie in their mouth to say that indeed if a person went to the department to ask, he'll be precluded from there.
Shall we continue on some other day? I think it was quite heavy today.
As your lordship feels.
Sometimes beyond the point, we have some difficulty.
No, my lord, it's 4:45. My lord, it's been a long day for your lordship.
So,
So, Lord, Your Lordships can give me some time tomorrow, my Lord. I think we can finish it rather than taking the chance of going to next week.
Tomorrow it appears Arvind has some difficulty. So what I'm thinking is Monday, Tuesday, last week we have some division benches. I was thinking that on the tax roster day of next Wednesday, we'll conclude. We'll have it post lunch. We'll have lesser matters. Post lunch in one session, we'll complete it if Wednesday is okay for both of you. And if for some reason, it goes beyond, I will treat it as part heard and then we'll go about it, if for some reason. So removing that apprehension, we'll have it on Wednesday post lunch and we'll see what to do.
My Lord, I am willing to take a chance even on a Tuesday, my Lord, if possible.
We have some benches, Monday and Tuesday, some division bench, other part heard.
Anything, my Lord, Your Lordship.
Yeah. But I can say one thing, there is a broad consensus that this is a tentative finding. That's what Arvind said. And though you started off saying that tentativeness, not in that sense, but I think there is a consensus that the determination in this 195 by its nature is only tentative.
Tentative, my Lord, query the SSC. Final query, me, as far as I am concerned, I will be not, my Lord, saddled with any further consequences of non-deduction.
Arguments in senior counsel appearing on behalf of the petitioners remains inconclusive. This is the matter for further hearing at 2:30. List the matter for further hearing on 23rd. On 23rd. No, that's it. But I should say, I was in this tax roster, I'm impressed by Arvind's representation.
No, undoubtedly, he works very hard and he's very good, my Lord. There's no doubt about it. I join your Lordships in that appreciation.
Court officer?
Tomorrow, yes, put it. Can we ask for 3:30 in the afternoon? No, we should have asked him.
No, I was actually before another bench.
That's what even I realized. It's okay. Let's go.
Okay.
Same.
Court officer, serial number 36, third list, ಯಾವಾಗ ಹೋದ್ರಿ?
Serial number 36, ಅರ್ಜೆಂಟ್ ಸರ್, ಡೇಟ್ ಇಲ್ಲ ಅದು. ಸರ್ ನೆಕ್ಸ್ಟ್ 32, serial number 32, ಸುನೀತಾ ಶ್ರೀನಿವಾಸ್ ಮೇಡಮ್, ಅದು ನಾಳೆಗೆ ಹೋಗಿದೆ. ನಾಳೆ.
Yeah, okay, sir. Thank you.
Yes.